All right, good morning, ladies and gentlemen. My name is Judge Law, and we are going to begin with our Fulton State all-purpose calendar. This is a list of misdemeanor criminal cases in which individuals have cases in which they've already been accused. Bonds have been set, and today we're going to find out the status of the cases. We're going to include different proceedings such as plea hearings or an arraignment or any bond modifications that are being sought. If you are a defendant charged with a misdemeanor offense, please remember that you have a right to remain silent. Anything that you say about the facts of your case, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. All right, we are going to begin in courtroom 2. Who do we have, please?
Good morning, Your Honor. We got position number 17, Mr. Antoine Jordan.
Thank you. All right, Mr. Jordan, good morning. Your case is going to be 22 CR 007-565H, in which you're accused of reckless conduct from October 30th, 2022. Mr. Jordan, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. This is going to be a arraignment and a bond modification hearing. Is that correct?
That's correct, Judge.
All right. So this paperwork. And do you waive a reading of the accusation?
I do, Judge.
Thank you. All right, Mr. Antoine Jordan, and that in the case I've just mentioned, you have been accused of one misdemeanor offense of reckless conduct from October 30th, 2022, allegedly in Fulton County, Georgia. Based upon the accusation that's been filed against you, the case will then proceed on to trial upon your entry of a not guilty plea. Once I've accepted the plea, then the case will be scheduled for trial, at which time during the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Okay, Mr. Jordan, I'm still going to proceed with the arraignment. Please go ahead and log in. Thank you. All right, excuse me about that. So as I was saying, if you are found guilty of this offense after the state proves the charge against you beyond a reasonable doubt, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. How do you plead, sir?
No.
All right, Miss Helen?
I would like to give him a talk week. Can I give him an opportunity to give him a call, Judge?
All right, so Mr. Antoine, I thought you were going to, Mr. Joe, I thought you were going to plead not guilty, but apparently you may have had a change in mind. So your attorney is going to speak to you. Please step aside. Miss Helen will call you in a few moments.
Okay, Judge.
All right, just I'm going to take a pause. Deja Robinson.
And Judge, that's also my case.
Who is Deja Robinson?
I'm here.
Please start your video.
I'm trying to.
All right. I'm going to remove you from the Zoom because you have a very inappropriate picture for court proceedings. Once you remove that picture, then you may come on back to the Zoom. Thank you. All right.
That better, Judge?
That's better. Please place your screen on mute and do not switch off your video or otherwise remove that picture from your Zoom ID. Thank you. Okay, who do we have next?
Are we still going with Miss Helen's cases, or she's going to call her client?
No, you can go on with Miss Helen's cases. She'll talk to Mr. Jordan shortly when she doesn't have a case.
Okay, so we're going to go to position number 26, Sebastian Smith.
All right. Mr. Jordan, may I proceed? I see you walking in front of the clerk's office. I just need a thumbs up if I may proceed.
We're ready, Judge.
Thank you. All right, so we are on position 26. This is State versus Sebastian Smith, accused of willful obstruction of a law enforcement officer from November 1st, 2022. Mr. Smith, you've been advised of your right to remain silent, and your attorney is Ms. Helen. This is going to be a negotiated plea hearing. May I place you under oath?
Yes, ma'am.
Please
Yes,
raise your
ma'am.
right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Thank you. All right, we're first going to hear from Ms. Sowry. Ms. Sowry, what is the
offer.
offer? So sorry, I'm just blanked out right there.
No problem, Judge. The state's offer in this case is 12 months to serve 16 days, credit for time served 8 days, the balance probated, an MHET, and to stay away from the Motel 6 located at 1377 Virginia Avenue in East Point. Nothing further, Judge.
Ms. Helen, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
He does, Judge, and we do so stipulate. We also, since this is a probated sentence, we're asking for the probation fees to be waived at least 4 months, Judge. And since it's only the MHET as a condition, if the state is amenable, if it can go non-reporting once he completes that.
Any objection to non-reporting?
No objection, Your Honor.
All right. I'm going to waive the probation fees up to and including March 2023. All right, with regards to Mr. Smith, I'm going to ask you some questions to make sure that you are pleading guilty willingly, voluntarily, and knowingly. So, Mr. Smith, first of all, have you consumed any medication or alcohol recently? Could we unmute courtroom 2, please?
No.
And are you satisfied with your attorney's representation?
Yes.
And have you understood the proceedings so far?
Yes.
Right. And has Ms. Helen gone over all your waiver of rights, including the right to a trial, right to confront your accuser, the right to challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt?
Yes.
Have you understood her explanations?
Yes.
And how do you plead to one count of willful obstruction of an officer?
Guilty.
The sentence is going to be 12 months to serve 16 days, credit for time served 8 days. If you have no other cases holding you at the jail, then your jail time is concluded and you'll be released within 24 hours.
Oh.
You must report to the probation office next week, next Thursday, and that would be November 17th at before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you are on probation, you do not need to pay probation fees from now until the end of March 2023. During which time you have to go to a healthcare provider and obtain a MHET. Your probation officer will explain to you what an MHET is. Do you understand?
Yes, ma'am.
All right. If you complete your MHET before the end of March 2023, then your probation will be non-reporting. Otherwise, you start paying probation fees from April 1st, 2023. Thank you.
Thank you.
Thank you, Judge.
Next, we have position number 16, Mr. Cedric Jones.
And still Miss McLean's cases. So we're moving on.
Judge, he has 1 through 14. I have 15 through 30.
Got it. Thank you. This is State versus Cedric Jones, accused of 4 counts of giving false information to a law enforcement officer from May 5th, 2019. Mr. Smith, you've been advised of your right to remain silent, and your attorney is Ms. Helen. This is going to be a negotiated plea hearing. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am, yes, ma'am.
Thank you. Ms. Sowry, what is the plea offer for the state?
Yes, Your Honor. This offer is 12 months to serve 11 days, credit for time served 11 days, and the balance suspended.
Thank you. Ms. Helen, do we stipulate to the factual basis, venue, and ID? And do you Does your client accept these terms?
We do, Judge, and we ask this court to accept the plea as negotiated.
Thank you. Mr. Jones, have you consumed any medication or alcohol recently? Have you consumed any medication or alcohol recently?
Ma'am, no, ma'am.
And have you understood the proceedings so far?
Ma'am, yes, ma'am.
And are you satisfied with your attorney?
Ma'am, yes, ma'am. Very. Yeah.
All right, that's good. And is anyone forcing you to take a plea today?
Ma'am, no, ma'am.
Has your attorney explained all the waiver of rights that you would have to give up, the rights that you'd have to give up in order to enter this plea?
Ma'am, yes, ma'am.
And have you understood her explanation?
Ma'am, yes, ma'am.
How do you plead to 4 counts of giving false information to an officer?
Ma'am, guilty, ma'am.
Your sentence is going to be 12 months to serve 11 days, credit for time served, 11 days, balance suspended. This case is now concluded. You don't have any further obligations in this case. Thank you.
Ma'am, yes, ma'am.
Thank you, Judge.
All right. We are at 4 North. Who do we have?
Yes, I have position 10, Judge.
All right, that's Mr. McLean's case. Ms. Helen, if you wanted to speak to Mr. Antoine Jordan, please.
I'll call now, Judge.
Thank you. Did you say 10 or 6?
I have position 10, Mr. Durham.
10. All right, thank you. All right, this is, excuse me. Quintavious Durham, case number 22 CR 007-557A. Mr. Durham has been accused of misdemeanor willful obstruction of an officer from July 9th, 2022. This is going to, Mr. Durham, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. Do you see Mr. McLean on the screen? I don't see Mr. McLean on the screen.
No.
All right, he's getting seated now.
Oh, I see him.
And he's going to wave his hand in front of him. All right, there we go. Good morning, Mr. McLean. Okay.
Morning.
All right, so Mr. Durham, since this is a negotiated plea hearing, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Sowry, or sorry, Mr. Is it Ms. Taylor? Mr. Taylor?
Yes, Your Honor.
All right, Mr. Taylor, good morning.
Good morning.
And what is the plea offer for Mr. Durham?
The plea recommendation in this case is to plead to count 1, obstruction for 12 months to serve 248 days, credit for time served 124 days with the balance suspended.
Thank you. Mr. McLean, does your client stipulate to the factual basis, venue, and ID? And do you, does your client accept these terms?
Your Honor, he does accept those terms, and we do so stipulate to the venue and factual basis.
Thank you. All right, Mr. Durham.
Yes, ma'am.
Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Have you understood the explanations that your attorney has given you, and are you satisfied with this representation?
Yes, ma'am.
All right. Is anyone forcing you to take a plea today?
Ma'am.
Is anyone forcing you or inducing you to take a plea offer today?
No.
If you decide to plead guilty to this charge of willful obstruction, you would have to give up your constitutional rights to a trial to confront your accuser and have the state try to prove the charges against you beyond a reasonable doubt. Has your attorney explained those waiver of rights to you?
Yes.
And have you understood him?
Yes.
How do you plead to willful obstruction of an officer?
Guilt.
Your sentence is 12 months to serve 248 days, credit for time served 124 days. The balance is suspended, so any obligations on this case is now closed. Case is over. Thank you.
Okay, thank you.
Your Honor, we have submitted the plea paperwork. There is no contact sheet needed, so that is done for us.
All right, thank you. Courtroom 2, who do we have, please?
Next, we have position number 23, Mr. Sandy Phillip.
This is Sandy Donovan Phillip, case number 20 COB 0000235. Mr. Phillip has been accused of simple battery from June 18 2020. With regards to this position, this is going to be a non-negotiated plea. Jail time and anger management seems to be at issue. Is that still the position, Ms. Helen?
That is, Judge.
All right. Mr. Phillip, we are going to have a non-negotiated plea hearing, which means that the state is going to give me one recommendation, and then I'm going to hear from your attorney. I will make a decision as to which recommendation I will accept, given the nature of the charge as well as your criminal record history, and then we will proceed accordingly. You don't have to make a decision until I let you know what my decision is. Keep in mind that I also have the right to disregard either recommendation and schedule this case for trial. Do you understand?
That's fine.
All right, thank you. Ms. Sari, what's the recommendation for Mr. Durham? Just one second. Lamar Harris, please mute your screen. Please mute your screen. Thank you. Go ahead, Ms. Sari.
Yes, Your Honor. The offer in this case is 12 months to serve 90 days, credit for time served 8 days, the balance probated, a 12-week anger management course, no contact with the victim, Stephanie Dunn, and to stay away from the JJ grocery store located at 507 Joseph E. Lowry Boulevard in Atlanta. Your Honor, this is a simple battery charge where the victim called officers to report that she was slapped numerous times by the defendant. And she and the defendant used to be in a relationship. Your Honor, the reason that we are going so high on the jail time is because this defendant has a 2019 ag assault guilty conviction against this very same victim. In that case, her eye was seriously disfigured and her orbital bone was fractured and she had a blood clot. So, Your Honor, this defendant does present a significant risk of intimidating this victim. He presents a risk of reoffending. He picked up this case after the first case. So that's why we are asking for the 90 days and the 12-week anger management course. Nothing further.
Thank you. Ms. Helen?
Yes, Judge, this is a non-negotiated plea. I just want to make a correction here. Mr. Phillips is here because of an FTA from May 26th of this year.
That's
This
noted. Yeah, I've got that.
I figured you would have saw that, Judge. So he's not here on a new charge. This is not this case happening before or another case happening before this case. He's on probation for that other case, Judge, which he reports. And he's doing what he needs to do for that felony probation, Judge. For this case, he understands that he did something wrong and he wants to resolve it. But it was a failure to appear, not another case that has him here, Judge. So we are asking for time served for the 8 days that he's done, be time served for this. He agrees to the probation. He agrees he did something wrong, Judge. He wants to resolve this case. The 12 weeks of anger management, he cannot afford that because he's lost all employment due to incarceration. I'm asking this court to consider 20 hours of community service in exchange for those 12 weeks of anger management. And this is about a 3-year-old case at this point, Judge. He has had no contact with Miss Dunn at all. No contact, once, no contact. And also has stayed away from that grocery store, Judge, and understands he can't go back there. So we are asking for time served with the probated sentence, Judge.
And Your Honor, briefly, this case happened in 2020. His ag assault case was in 2019. So he had the ag assault and then he picked up the current case. So I just wanted to clarify that for the record, as well as the 20 hours of community service, Judge. That would not be appropriate in this case. Again, he had an ag assault, most likely a no contact order, and violated that and picked up the case that's before you today. So that's why we are asking for that additional jail time.
And the case in which the victim allegedly sustained a fracture to an orbital bone, that's from the felony case, correct?
That's
Correct,
correct,
Judge.
Judge.
And this is the same victim.
Correct, Judge.
Yeah, that's what I figured. And this were back-to-back, 2019, 2020. Yes, I agree with Ms. Helen that it is an older case, but that doesn't mitigate the fact that this was a pattern of violence directed at the same individual. And the state's recommendation does reflect the seriousness and the gravitas of this particular case. So I'm going to accept the state's recommendation that Mr. Phillip complete 12 months to serve 90 days, credit for time served 18 days. So he would have I believe,
Judge, it was 8 days.
oh,
Credit for time
time
served
served 8 days, sorry. So according to this, 7, 8, 9, he would have about 35, 36 days left.
Correct, Judge. I had 30 additional 7 days or 37 additional jail days with the states.
37, yeah, it'll be, 37 additional days, after which he'll be placed on probation to complete the 12-week anger management program. No contact with Stephanie Dunn, stay away from the J&J grocery store. And the 12-week anger management program would have to begin within 60 days of being released from the Fulton County Jail.
Judge, can I speak to Mr. Phillip prior to him making a decision on any of this?
All right. That sounds fine. Okay, we will resume the plea hearing if Mr. Phillip still would like to proceed. Mr. Phillip, please have a seat aside. Miss Helen's going to speak to you shortly. Have you completed your case with Antoine Jordan?
I have, Judge. I'm ready for that case.
Antoine Jordan was 26, was it?
Position 17, Your Honor.
17, sorry.
Your Honor, when convenient, may I interject?
Yes.
Your Honor, I need the courtrooms to call me on Burke, Fleming, and Dewberry at their convenience to my cell phone. I will find a confidential place in the adjoining room to speak to those three people, Burks, Fleming, and Dewberry.
Dirks, Fleming, and Dewberry. Okay.
Correct. And
If you'd like to put your cell number in the chat to courtroom 2.
oh, I don't mind announcing it. It's 770-891-4755. I give that out. 770-891.
McLean, you're gonna call extension 22392.
Okay, understood. Yeah.
2392. I'll call 2392.
Yeah, it's a 2392. Yeah. Okay.
Right. It's a 612 number.
Yeah. Okay.
I'll do that.
So, yeah, anything else?
Yes, Your Honor. Number 1 is a negotiated plea of guilty.
All right. So is that who we have in the courtroom, courtroom 2?
I don't know. We have position 17.
17. Okay, that was Mr. Antoine Jordan. How will we proceed? We are resuming with 22 CR 007565H. How are we proceeding, Ms. Helen?
Judge, this will be a bond hearing and an arraignment.
Okay, so I've already gone through the soliloquy with Mr. Jordan. Mr. Jordan, I've advised you that what would happen if the case goes to trial and the state carries its burden of proof or beyond a reasonable doubt. Given that information, how do you plead?
Not guilty.
All right, your case has been arraigned. Let's go ahead and address your bond. Let me see. Go ahead, Ms. Helen.
Yes, Judge, this is a bond hearing. We are asking for a bond modification. Firstly, we are asking for a signature bond of the same amount in a $5,000. If Your Honor feels that he is ineligible, we're asking for a bond modification or reduction to no more than a $1,000 surety. And I'll get into the reasons why. Mr. Jordan is 39 years old. He is a lifetime resident of Georgia, specifically Fulton County, was born at Grady Hospital, went to Washington High School, also has his GED. He has 2 primary children that he takes care of. One is the alleged accuser in this case, and then he has another son or another child, Judge. He also volunteers for the community. He volunteers to support his family additionally as well. He has a sister here in Georgia as well. He is the primary caregiver of his wife, Miss Jordan LaMarjorie. She has a severe disability that prevents her from working, walking, and he, as a primary caregiver of her and his household, takes care of everyone there, is a financial provider for everyone there. So let's get into the Ayala factors. I don't believe that he's going to miss any court dates, Judge. I have a permanent address. I have a good phone number. I don't believe he's a danger to the community. I have his wife here who's, I hope, is going to testify to how much he supports that family and how much he supports that local community. And then, Judge, I don't believe he's going to be rearrested for any charges, Judge. So in this case, we are asking for that signature bond, if not that bond modification, Judge. He is, again, I do have his wife here who I do believe is going to speak on his behalf.
Okay, he's got a Clayton County hold, right?
Yes, Judge. I believe
No bond? Yeah,
that's correct, Judge. I believe that's a probation hold.
all right, so even if I give him a lowered bond, it would be a release only to Clayton County.
Correct, Judge, but he needs to go to Clayton County to handle that case too, is what we discussed.
Okay. Ms. Harrison, could you reiterate his prior GCIC?
Morning. He has 29 cycles with history in Georgia and Tennessee. His last arrest in Georgia was a probation violation in 2021. His record indicates a 2017 failure.
Failure
That's
to
on no, to R,
register?
yes.
Okay,
And a 2011 CWAC charge out of Clayton.
all right, thank you, that's good.
9 violations of probation.
9 probation violations, okay.
Correct.
All right. All right, Ms. Sowry, do you have a response?
Yes, Your Honor. The state's position is for the bond to remain as set. In this case, this was an unlawful charge of a firearm in the presence of the victim, who we've heard from the defense counsel is one of the defendant's children, whose name is Jeremiah Harris. We've heard pretrial give the history. I just want to add in there that he does have a 2017 battery NOLO out of Clayton, a 2017 battery guilty here in our county. He also has a 2017 and 2019 failure to register as a sex offender.
Whoa, Miss Sowry, I mean the state, come on.
Your Honor,
No, I'm not gonna go through it again. The Solicitor General's office has to be put on notice that I will not let any sensitive CWAC matters be announced in open court. All right? Ms.
Your Honor,
Sowry?
if I could
No,
respond.
Mr. Walker, you may not. You may not.
Well.
No, you may not. You mute Ian Walker. Mute Ian Walker.
Criminal history of a.
Will the host please mute Ian Walker? Thank you. All right.
Your Honor,
No, Miss Sowry, you're done.
okay, Your Honor.
All right, you are done, Miss Sowry. Miss Sowry, you are done.
Okay.
If anyone from your office violates my simple request that any sensitive convictions, cases, and charges are announced in open court, I'm not going to let you move any further. Mr. Jordan, with respect to your criminal record history, with respect to, well, let's hear from the wife first. Mrs. Jordan?
Yes, ma'am.
All right. Ms. Jordan, now you've heard, I understand that you want your husband released on the lower bond, but I am got great concerns that Mr. Jordan has a significant history of violations, significant history of not complying with probation, and a significant history of especially violent offenses. I'm very concerned that if I release him, that he's not only going to pose a very great threat to re-offend, but he's also going to pose a threat to the alleged victims and his community. Can you give me your very best argument of why you believe he should be released? And it's not because he has to look after you or because he's the primary earner. He is clearly a threat to the community.
Ma'am, he just have a little anger problem. He like need to be in like an anger management class.
Okay.
But he's a good person. He's a really good person. He works. He take care of the house. He take care of me. I'm very sick. I'm on oxygen. I have sleep apnea problem. I'll be stopping like breathing in my sleep and a lot of things. Like I'm real sick. I'm diabetic, and he really take care of me. He do whatever I tell him to do. He'll do it. He take good care of his kids.
And who is Jeremiah Harris?
You said what, ma'am?
Who is Jeremiah Harris?
He's my son. My son, he's like ADHD. He have an anger problem too.
All right, understood.
And like when like if things he don't get his way and stuff, he's terrible too.
All right. And
Like
you
he
put-
don't.
okay, thank you, Ms. Harris. I understand your particular situation. I do. But unfortunately, what we have is a case in which a firearm was discharged. This has gone beyond being anger. This has gone into very, very dangerous act of violence. And we know too much in the history of our cases that it never comes out to any good when someone in anger discharges a firearm. The bond modification is going to be granted. Mr. Jordan's bond is going to be set at $3,500. It is a surety bond, and that's the lowest I can go on this bond because Mr. Jordan has a history of violence and non-compliance. All other conditions remain the same. Thank you, Ms. Helen. Please submit the proposed order to our litigation manager, and that's going to be, I think it's either Mr. Jordan,
Ms. Strong, or I'll submit it to Ms. Strong or Mr. Jordan.
okay. Is it Ms. Strong? Okay.
I do. Yeah, I think it's Ms.
All
Strong.
right.
And Ms. Harris, I'll speak to you. Thank you so much. You can log off.
Next case, please.
Thank you, Judge.
Next, Your Honor, we're gonna go to position 18 and position 19.
All
Mr.
right,
Lane.
thank you.
Hey,
All right, that's okay, Ms. Harris, we'll take care of it. The host could please remove Lamar, the Zoom panel. Thank you, okay. We have Ephraim Floyd Lane accused of, in two different cases. The first one is 21 CR 007735J, disorderly conduct from October 4th, 2021. The second case is 22 FTA 000014, and this was a failure to appear for a particular fingerprintable charge from September 19th, 2022. Mr. Lane, you've been advised of your right to remain silent, and your attorney is going to be Ms. Helen. This is positions 18 and 19.
Correct, Judge.
All right, and these go, okay, Ms. Sowry, the state is going to null pros position 19, correct?
That's correct.
All right, so we are addressing a negotiable plea in position 18. Mr. Lane, it appears that you're going to take a plea on one of the two cases. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, Mr. Lane, excuse me, Ms. Sowry, what's the plea offer for disorderly conduct?
Yes, Your Honor. The offer is 12 months to serve 28 days, credit for time served 14 days, the balance suspended, no contact with Ross Bernhapt, that's BERNHAPDT. Stay away from the Flat Shows Grocery Market at 1263 Glenwood Avenue in Atlanta. Nothing further.
1263.
1263.
That's correct.
All right. All right, Ms. Helen, do you stipulate to the factual basis, venue and ID, and does your client accept these terms?
We do accept, Judge, and we do stipulate to the factual basis, venue and ID.
All right. So, Mr. Lane, with regards to the charge of disorderly conduct at that grocery store, first of all, are you under the, have you consumed any medication or alcohol recently?
No.
And have you understood and are you satisfied with your attorney's explanations?
Yes.
And is anyone forcing you or inducing you to take a plea today?
No.
In discussing this case with your attorney, she would have gone through all the rights that you would have to give up in order to enter a guilty plea to this charge.
Yes.
Have you understood her explanations?
Yes.
And have you understood the waiver of rights?
Yes.
How do you plead to one count of disorderly conduct?
Yes.
Your sentence is 12 months to serve 28 days, credit for time served 14 days, balance suspended. You are to have well, that means your jail time for this case is closed. And if you have no other holds at the jail, you'll be released within 24 hours. You are to have no contact with Ross Bernhardt, and you cannot return to that grocery store at 1263 Glenwood Parkway. Understood?
Yes.
If you return to that grocery store, they will arrest you for criminal trespass, and we get to do this all over again.
Okay.
All right, thank you.
Position 27, Thomas.
This is State versus James Thomas, 22 CR 007404C. Mr. Thomas has been accused of public drunk, fair evasion, and criminal trespass. This is from an October 27, 2022 incident. This is going to be a negotiated plea. Mr. Thomas, you've been advised of your right to remain silent, and your attorney is going to be Ms. Helen. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide during this plea hearing will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Sari, what's the plea offer, please?
Yes, it's 12 months to serve 28 days, credit for time served 14 days, the balance suspended, and to comply with MARTA suspensions, if any.
All right, Ms. Helen, do you stipulate to the factual basis, venue, and ID for this particular case? And does your client accept the terms?
He does, Judge, and we do so stipulate.
All right. Mr. Thomas, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
And with regards to this case, has your attorney gone over all the rights that you would have to give up in order to enter a guilty plea?
Yes, ma'am, she had.
All right. And Mr. Thomas, how do you plead to one count of public drunk, one count of fair evasion, and one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days, balance suspended. You would have to comply with any MARTA suspension that is still active. So you would need to call MARTA headquarters at Lindbergh Plaza. You cannot go to any of the train stations or any of the bus stations or use any services while you have an active MARTA suspension against you. Understood?
Yes, ma'am.
All right. Thank you.
Judge, I have position
Go, go, go.
21.
All right. 21 at 4 North. I have Willie Myers, case number 22 CR 007578J. Mr. Myers is charged with one count of obstruction of a law enforcement officer, one count of possession and use of a drug-related object, and possession of marijuana less than 1 ounce from June 3rd, 2021. This is position 21, and this is going to be an arraignment and a bond modification hearing. Is that correct, Ms. Helen?
Judge, I believe it's just an arraignment. I believe he bonded out on this case. If I could just have pre-trial confirm that, or I believe he did. So
Position 21, Mr. Myers. Oh, I don't see that, but
I don't see it on my end either, Judge.
Ms. Harrison, do you know if Mr. Myers has been released on bond?
I do not, Judge.
I did, yeah.
He's not holding on this case.
that's what I thought. I didn't see my case particularly holding him.
This
Okay.
case was accused because he was in jail already.
Okay, but does he have a bond on these charges or?
It's probably a bind over.
Okay,
We could go, I mean, I can go through and see if I can find the original case, but it's probably a bind over case.
all right, thank you, Mr. Jordan. All right, Mr. Myers,
Yes,
We are
yes, Your
going
Honor.
to, we're going to arraign your case, which means that upon your entry of a not guilty plea, the case will be scheduled for trial. Do you waive a reading of the accusation, Ms. Helen?
I do, Judge.
All right. Mr. Myers, you have been accused of these 3 misdemeanor offenses that I just listed. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecution has the complete burden to prove the charges against you beyond a reasonable doubt. If the state prevails, you could be convicted of 1 or more years in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
I plead guilty, Your Honor. I,
Mr.
Also-
Myers, hold on. Mr.
Ma'am?
Myers, can I get opportunity or a breakout to speak to Mr. Myers?
ma'am, yes, Ms. Helen?
Can you hear me? Can I get an
Yes, I can.
opportunity to have a breakout room with Mr. Myers?
Yes, you may. All right, 4 North, we're going to place Mr. 4 North in a breakout with Ms. Catrice Helen. Courtroom 2, just 1 second. Courtroom 2, who do we have in the seat? Courtroom 2, who do we have?
Your Honor, this is position 6 and 7, Ronnie Brown. The
All right.
McLean is on the phone with one of his clients.
All right, we need to let Mr. McLean know that he needs to stop that call now. We will go to position 6 and 7, then he can resume that conversation. Mr. Jordan, please place 4 North and Catrice Helen in a breakout. 4 North, you're going to see a message on your screen to join the breakout. All right, so Mr. McLean, please return to address position 6 and 7, and then I'll let you go back to your conversation.
Got some further announcements?
All right, yes, sir. So Mr. McLean, are you, yeah, you're back, excellent. Okay, I'll let you go back to your conversation shortly. Right now, we are addressing Ronnie Brown, position 6 and 7. Mr. Ronnie Brown's cases are 22 CR 007370E, in which he's accused of theft by shoplifting, willful obstruction of an officer, and possession and use of drug-related objects from October 26, 2022. His second case is 22 CR 007371E. He's accused of 5 separate counts of theft by shoplifting, ranging in dates from October 9th, October 20th, October 14th, October 19th, and October 16th of 2022. This is going to be a negotiated plea. So, Mr. Brown, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Taylor, is this going to be a negotiated plea?
Yes, Your Honor.
And is it going to be a consecutive sentence?
No, Your Honor, it will be a concurrent sentence.
All right. Let's hear your plea offer for positions. Oh, is it going to be a global offer for all charges?
They are separate. I've divided them separately.
Okay, then let's start with position 6.
For position 6, he is to plead at count 1, theft by shoplifting. The state will be null processing count 2 and 3, obstruction and possession of drug-related objects. Plea recommendation is 12 months to serve 60 days. Credit for time served 15 days with a balance probated. He's to take a theft prevention class, alcohol and drug treatment and evaluation and recommended treatment. And he's to stay away from the incident location, the Texaco, located at 3 Joseph E. Lowry Southwest.
All right. And what is the recommendation for position 7?
He is to plead to counts 1, 2, and 3, theft by shoplifting, and counts 3, 4, and 5 will be null prossed. It will be a $500 fine, 12 months probation, 60 days to serve, credit for 15 days already served with a balance probated. He's to take a theft prevention class, alcohol and drug evaluation, recommended treatment. and those can run concurrent with the other ones in the other case. And he is to stay away from the Mobile gas station. And Your Honor, this took place at multiple Mobile gas stations, so we would just ask that he stay away from Mobile in general.
All mobile gas stations.
Yes, Your Honor.
All right. And with respect to, so you're saying that this is not a consecutive sentence?
No, Your Honor, the probation and the time will run concurrent in both cases.
All right, so both of them will be 12 months to serve 60 days, credit for time served 15 days.
Yes, Your Honor.
All right, and so he'll have 15 more days to serve at the jail.
Yes, Your Honor.
All right. Mr. McLean, with respect to both these cases, does your client understand that he'll be in jail for 15 more days, after which he'll be placed on probation?
He does, Your Honor.
All right, and do you stipulate to the factual basis, venue, and ID for all
We-
these theft by shoplifting charges?
We do so stipulate count 1 on position 6 and counts 1, 2, 3 on position 7.
Okay, and has he agreed to these terms?
He has. We've gone over them. He understands to stay away from mobile gas stations and to stay away from the Texaco.
All
He
right,
understands there will be some effort, some real effort involved in getting done the ADET and getting the class done and reporting to probation.
all right, and he's what, 31 years old, 32?
Right, Your Honor, and we've asked for any financial breaks that the court could give him. He's going to have a financial burden in taking the classes.
All right. This is anti-theft class and alcohol drug. I'm going to waive your probation fees up to and including March of 2023. And given the numerous theft by shoplifting charges, Mr. Brown, you have to report to probation every month. There is going to be no non-reporting. You must report every month. So by April 1st, 2023, make sure that you have a job, that you're employed, and when you're reporting, you will start paying probation fees from April 2023 onwards. Do you understand?
Yes, ma'am, will do.
All right. And you also understand that since you are pleading guilty to 4 theft by shoplifting charges, any subsequent arrest, that means if you are arrested again for theft by shoplifting, it will automatically be a felony charge, which means that you could go to prison for more than 1 year and pay more than $1,000 in fines.
Yes, ma'am, it's all over for that.
Well, I hope so for you. Okay.
That's believe it.
All right, Mr. Brown, you've already been placed under oath. Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood your attorney's explanations?
Yes, ma'am.
And are you satisfied with this representation?
Yes, ma'am.
You can put your hand down, sir.
Oh,
All right. And is anyone forcing you or inducing you to take this plea offer today?
no, ma'am.
And are you doing so freely, knowingly, and voluntarily?
Yes, ma'am.
If you decide to take this plea offer, you do understand that you have 15 more days to serve at the county jail, and then you will be on probation for the rest of the,
Yeah.
I guess about 10 months.
Yes, ma'am.
All right. Mr. Brown, if you decide to plead guilty to these 4 charges, you would have to give up your right to a trial before a judge or a jury, to confront your accuser, examine witnesses, have the assistance of counsel to challenge the state's evidence, and have the state try to prove all these charges against you beyond a reasonable doubt. Are you prepared to give up all these rights?
Yes, ma'am.
In case number 22 CR 007370E, 1 count of theft by shoplifting, how do you plead?
Guilty.
In case 22 CR 007371E, 3 counts of theft by shoplifting, how do you plead?
Guilty.
All right. With respect to your guilty pleas, your sentences are going to run concurrent in both cases. And it is 12 months to serve 60 days, credit for time served 15 days. You have 15 more days to serve at the county jail. Once you've served the additional 15 days, you must report to the probation office at 132 Mitchell Street. You may report within 7 days of being released, but it must be either a Tuesday, Wednesday, or Thursday. Do you understand?
Yes, ma'am.
The probation office is located at 132 Mitchell Street in downtown Atlanta. And while you're on probation, I will waive your probation fees up to and including March of 2023. After that, you will still continue to report to probation and start paying probation fees from April 1st, 2023 onwards. You are to stay away from the Texaco gas station at 3 Joseph E. Lowry Boulevard in Atlanta and from all mobile gas stations. Any gas station that has the word mobile on it, you're not allowed in there. Understood?
Yes, ma'am.
You are to complete a theft prevention class, and that must be completed before the end of March 2023. And you must submit yourself to an alcohol and drug evaluation and submit yourself to any treatment at your expense. And that must also be completed before the end of March 2023. Understood?
Yes, ma'am.
That completes your sentence. Thank you.
Position 21, Judge.
All right. Mr. McLean, you may go ahead and resume your conversation. We have position 21 at 4 North. And this is Mr. Myers. Ms. Helen, how are we proceeding?
And Judge, this is an arraignment. He is on a signature bond from East Point for this case, so it is an arraignment only.
All right. So as I was, we are resuming with Mr. Willie Myers, 22 CR 007-578J. Mr. Myers, I've already informed you of what happens once you enter a not guilty plea. So given that information that I provided, how do you plead?
Not guilty.
All right. Your case has been arraigned. And I understand from Mr. Jordan that he did receive a UJR through East Point Municipal Court. So that concludes this case. Thank you.
Thank you, Judge.
Next one, we have position number 13, Mr. Tyjuan Jackson.
I think Mr. McLean still has.
I can go ahead with that now, Your Honor.
All right, thank you.
Mr. McLean's other client said he's finished talking with McLean. He doesn't need to talk to him anymore.
Okay, sounds good. All right, we have position number 13, which is State versus Taiwan Askia Jackson.
Good morning, Your Honor.
Good morning. Good morning. Mr. Jackson, your case number is 22 CR 007-397C. Mr. Jackson, with respect to your case, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. This is going to be a negotiated plea. So, Mr. Jackson, may I place you under oath?
Yes, ma'am, Your Honor.
Raise your right hand. Do you use other right hand?
Right hand.
Yeah. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, Your Honor.
Thank you. All right, Mr. Taylor, what's the plea offer for Mr. Jackson?
Yes, Your Honor. In this case, he's to plead a 1 count of criminal trespass for 12 months, probation served 28 days, credit for time served 14 days with the balance suspended, and he is to comply with all current MARTA suspensions.
And we're going to null cross the fair evasion?
I'm sorry, Your Honor. It was a plea to count 1 and 2. I apologize.
No problem. Count 1 and 2. All right, thank you. Mr. McLean, do you stipulate to the factual basis, venue, and ID for this case? And does your client accept these terms?
We do stipulate to those 3 items, Your Honor, and he does agree to these terms.
All right, thank you, Mr. McLean. Mr. Jackson, have you consumed any kind of medication or alcohol recently?
No, Your Honor.
And have you understood and are you satisfied with your attorney?
Yes, Your Honor.
If you decide to take this plea, has your attorney explained to you that you would have to give up your constitutional rights to a trial, as well as all the other rights that go with it?
Yes, Your Honor.
And have you understood his explanation?
Yes, Your Honor.
How do you plead to 1 count of fair evasion and 1 count of criminal trespass?
Yes, Your Honor.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. The balance is suspended. That means your jail time and all obligations for this case is concluded, except that you have to stay away from all model property if there are any active suspensions against you. You would have to contact Modern at the Lindbergh Plaza and make sure that there are no suspensions against you. Understood? All right, that takes care of this case. Thank you.
Next, we have position number 15, Oscar Johnson, 15.
15 is State versus Oscar Johnson, 22 CR 007-423C. Mr. Johnson's accused of battery from October 28, 2022. It appears this is going to be a non-negotiated plea hearing, which means that Mr. Johnson, we are first going to hear from the prosecution, and then we will hear from your attorney. I will let you know which recommendation I'm going to accept before we proceed. You've been advised of your right to remain silent, and your attorney is Mr. McLean. Okay.
Ms. Helen will take this.
Miss Helen? Okay.
Yes, Judge, that's my case.
All right, Miss Helen. Okay, sorry about that. All right. Mr. Taylor, what's the recommendation for Mr. Johnson?
Mr. Honor, in this case, he is to plead to one count of battery for 12 months probation, served 30 days. Credit for time served 12 days with the balance probated. Is to have 6 weeks of anger management classes. No contact with the victim, Chester Stone Jr. And to stay away from the incident location at 160 Ted Turner Drive, which is a Circle K. This happened at the Circle K, and the victim was trying to talk on his cell phone, and the defendant came up to him and tried to speak with him, but was intoxicated at the time. They got into a fist fight, and officers reported to the scene.
All right. Mr. McLean?
Oh, Judge,
Miss Helen,
that's going to be.
I'm sorry. I'm so thinking.
Yes, Judge, this is a non-negotiated plea. Just a correction on the credit for time served. I believe he was 13 days. He was booked in October the 29th. So I believe that's 13 days. So essentially, we're 2 days from it being a time served deal. And so that's what we're looking for, Judge. We're just asking this court to consider the 13 days that he's been there, time served. He has lost all employment due to this incarceration, Judge. So the 6 anger managements, he won't be able to afford that. And so we're asking for a comparable swap of community service. I'm asking for the community service because Mr. Johnson already volunteers with the Atlanta Mission Christian Program. So he would be easily able to do a community service versus the anger management of having to pay that.
Ms. Harrison, how many cycles does Mr. Johnson have? Oscar Johnson.
One moment, Judge. He has cycles in Nevada, Illinois, Texas, Washington, Florida, and Georgia. Give me one moment.
That's okay. He's a multi-state offender?
Yes.
All right, that's good enough. Thank you. Miss Helen, I don't even need to listen to the prosecution. I'm going to accept the prosecution's offer in terms of requiring him to do a 6-week anger management program and to also be on probation while he's living in Georgia. I'm assuming he's a resident of Georgia?
Yes, Judge, he is.
All right. This is a multi-state offender in at least 5 states. It's rattled off by, as listed off by Ms. Harrison. Sorry, Ms. Harrison, I didn't mean to say rattled off. But, this is not a case that in which Mr. Johnson should not be taking anger management. So does your client still want to move forward?
Mr. Johnson, would you still like to accept this plea today? Mr. Johnson?
Don't charge.
Oh, no. Wait, Mr. Johnson. Let me get on the phone and speak to Mr. Johnson before we move on with the case, Judge.
All right.
Ms. Helen, you got 2 other clients too that need to talk.
Oh, we can move them at the end.
Right. No, we're going to do them right now.
Oh, yeah.
Mr. Johnson, go have a seat, and Miss Helen will call you shortly. We can call Miss Helen's next case.
Position 22 here, Judge.
All right. That's 4 North. At
22 is a private attorney, Judge, a David Houston, who's entered an appearance for this case.
David Houston, are you present?
This case was transferred, and I believe Mr. Houston is the attorney. I don't know if it's listed on Odyssey with this case number, but it's definitely listed on Odyssey under 22 CP 213608.
All right, Ms. Sowry, do you have any information about position 22, Mr. Richard Patatin Quitter?
Your Honor, we have that it's a private attorney. I don't see it being a matter we can address today because there's no offer, and it was transferred to the DA's office, this case.
It's already been transferred?
Yes, Your Honor.
But Judge, I have from Odyssey, from the case number I gave, that it's been transferred back to state court November the 1st. So maybe if I give the case number 22 CP 213608, it has that information that it was transferred back to state court.
And Your Honor, by operation of law, this case would be a felony.
Well, apparently, let's find out what happened. This is a 22 CP 213628. And this incident occurred on October 29th, 2022. I honestly don't know how it would have worked so fast because it's been less than 2 weeks. So let's see. (22 CP 213628). All right. All right, this is, did you say 22 CP 213628?
22 CP 213608.
608, sorry.
And Ms. Helen, when you get a chance, can you call that 22392? You got 3 of your clients waiting to talk to you.
Sure.
Thank you.
All right, Ms. Sowry, it looks like on November 1st, Assistant District Attorney White, WIGHT, transferred it back to state court. And it looks like Mr. Patatin Quiterio's attorney is David Houston. I do not see a David Houston on the Zoom call. I'm going to sound up for him one more time. Attorney David Houston. All right. Mr. Patatin Quitter's case is going to be reset to November 17th for his attorney, David Houston, to be notified that the case is back with the state court and that, oh, I've got a note here that David Houston's a public defender. So it may be David Houston, public defender for felony cases. So it looks like this may belong to the public defender's office. So I'm going to reset this case to November 17th, SAP calendar for the public defense attorneys to speak to Mr. Patatin Quitter.
Understood, Judge.
Thank you.
And next, Your Honor, we have position number 5, Mr. Anthony Bills.
That is ready.
All right, thank you. We have State versus Anthony James Bills, accused of theft by receiving stolen property on February 6, 2019. This is case 19 CR 010176Y. Mr. Bills, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. And this is going to be a negotiated plea. So may I place you under oath?
Yes, ma'am. Go on.
Do you please raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Mr. Bills, we're going to hear from the prosecutor first. Mr. Taylor?
Yes, Your Honor. The plea as negotiated is to plead to count 1, theft by receiving stolen property. for 12 months to serve 60 days, credit for time served 17 days, the balance probated. He's to take an anti-theft course, have no contact with the victim, Jocelyn Murchison, and there is no restitution in this case as the victim got her items back.
All right, thank you. Mr. McLean, do you stipulate to the factual basis, venue and ID, and does your client accept these terms?
Yes, Your Honor, we extensively discussed the police report and any connection between him and the theft that was in the police report. And he does ask me to stipulate to those items, including venue, ID, and the factual basis.
And does he understand that he has 13 more days to serve at the Fulton County Jail?
Believe we calculated approximately the 21st or 20th or 19th of November would be his out date. And is that 13?
No,
We were thinking it would be in the neighborhood of 9 or 10 more days, Your Honor.
it will be 23rd, November 23rd. It's 60 days. He's been given credit for 17 days. So if I did,
I think he had a couple of days in a previous jailing, but I'm not sure this is, if I could look at the facts, I could take a look. But there was some glitch. There was some reason why we were thinking 9 or 10. Or would the state want to just, would the state want to just adjust so we could?
let's see. I don't have,
Let's see, bills, he's number 5. Do you see the notation at the bottom of the calendar entry for position 5, 2 days back in 2019?
so they're giving him credit for 17 days. This is Anthony Bills.
Right.
Mr. Taylor, I've got here, he was confined 21 days. And that he also stayed 3 days back in 2019 in jail. So that would be credit for 24 days. Would you agree, or was there a reason y'all were going with 17 days?
I'm sorry, Judge, I'm just now seeing that I do see the 21 days for the charge.
And if you scroll further under booking number ending in 1923-598, he served 3 days on December 12, 2019.
All right, the state has no problem giving him credit for the time that he's already served.
All right, so that would bring it down to serving 6 more days, which means that he would be released on the 16th. Is that your understanding, Mr. McLean?
Yes, Your Honor, that's even a day better than we were calculating, but we're not the best at math.
Oh, don't say that. Okay. All right. So, Mr. Bills, have you consumed any medication or alcohol recently? Let's go ahead and unmute courtroom 2.
No, Your Honor.
And have you understood your attorney's explanations, and are you satisfied with his representation?
Yes, Your Honor.
If you decide to take this plea offer, you do understand you have 6 more days to serve at the jail?
Yes, Your Honor.
And once you're done, you'll be placed on probation. Is that your understanding?
Yes, Your Honor. Okay.
All right. And is anyone forcing you to take a plea offer today?
No, Your Honor.
Mr. Bills, if you decide, and I'm sorry, when you spoke to your attorney, he went over the waiver of rights with you?
Yes, Your Honor.
So you understand that you would have to waive your right to a trial, to confront your accuser, examine the witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. These are some of the rights that you'll be waiving.
Yes, Your Honor.
All right. How do you plead to 1 count of theft by receiving stolen property?
Yes, Your Honor.
Your sentence is 12 months to serve 60 days, credit for time served, 24 days. You'll be placed on, once you have done your additional 6 days, you will report to probation, and your report date will be, you're released on the 16th. So you must report on November 22nd. That's a Tuesday. Understood?
Yes, Your Honor.
Well, you report on November 22nd. And once you're on probation, you have to complete an anti-theft class and have no contact with Jocelyn Murchison. I will waive your probation fees from now until the end of the year. So if you complete your class by the end of the year, then any objection to non-reporting, Mr. Taylor?
No objection, Your Honor.
All right. If you complete your probation, your anti-theft class by the end of the year at your expense, then your probation will be non-reporting.
Yes, Your Honor.
All right, thank you. I have our Spanish interpreter here for Mr. Joel Alvarez. Is that your client, Mr. McLean?
It's going to be my client, Your Honor. I do need to speak with him through the interpreter.
All right.
Good morning, Your Honor. I'm right here.
All right, Miss. Let me see.
Your Honor, Ms. Helen is still on the phone with her clients. Can we push the Spanish interpreter back a little bit so we can get the rest of Mr. McLean's clients?
Yeah, they'll be fine, except that I also have to have it such a way that Mr. McLean can call the jail and three-way the Spanish interpreter on the call.
Yeah, I
Miss
can do
Lynn,
that.
do you
I can
do
do
you know
that.
how to three-way a call?
I can do the three-way call, or they can.
All right, so Miss Lynn, could you place your number to SCOG 33 defendant? Oh, I don't know what, would you be able to see on the chat?
Yes. Which one do you want me to send it to, Your Honor? SCOCG 33?
Defendant,
Defendant.
DF and DNT.
Got it. Okay, I'll
Good.
send it right now.
Judge, can she send it to me? I don't think he can.
Yes.
Oh,
Yes,
okay.
it's
on that.
Send it
So-
to Michael Jordan, and he would
Right.
be
Okay,
at state court
sure.
clerk.
Yes, I will do that right now, Your Honor.
All right, Mr. McLean, you'll get Miss Lean's number from Mr. Jordan.
Yes.
Okay. Mr. McLean is going to come back. What's the next case in courtroom 2?
Are we done with Mr. Bills?
Yes, we are.
Okay. Next, we have position number 9, Mr. James Dewberry.
I've got an announcement, Your Honor, in Dewberry. Let's see, let me see which person is which to make sure we had some paperwork there. Your Honor, that is a negotiated plea now.
Okay.
May I also announce, Your Honor, that I would like to ask for a negotiated plea, I believe, in Mr. Burke's situation, position 8. But that there was one person, let's see.
What about position 1?
Position, I'm sorry,
Position 1, what's the announcement?
that's a negotiated plea.
All right.
And thank you. And so Mr. Fleming, I'm going to ask for a reset, Your Honor. The state's recommendation would involve extra time, and I've explained to him that I do need to speak with him.
Okay, position 11 is reset to November 17th for a plea or arraignment.
Correct. Thank you.
Okay, so right now we have position 9, James Michael Dewberry, case number 22 CR 007396F. Mr. Dewberry is accused of criminal trespass from October 26, 2022. Mr. Dewberry, you've been advised of your right to counsel, and your attorney is Mr. McLean. Mr. Dewberry, may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, you may place your hand down. Taylor, what's the plea offer for Mr. Dewberry?
It is to plead to count 1, criminal trespass for 12 months probation, served 28 days, credit for time served 14 days with the balance suspended. He's to stay away from the incident location Videodrome at 517 North Highland Avenue Northeast.
Mr. McLean, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
We do so stipulate, and he does accept them.
All right, thank you. Mr. Dewberry, if you may unmute. Okay, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea offer today?
I don't know.
Has your attorney gone over the waiver of rights that you would have to agree in order to take this guilty plea?
Yes, ma'am.
I'm sorry?
What'd you say now?
Has your attorney gone over the rights that you have to give
Oh,
up?
yes, ma'am. Yes, ma'am.
Have you understood your attorney in terms of what are the rights you're giving up?
So far.
All right, just to make sure you understand that if you enter a guilty plea, you would have to give up your right to a trial. You cannot be before a judge or a jury in the future to challenge this charge, to confront your accuser, examine witnesses, have the assistance of counsel to challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. The remainder of the time will be suspended. You will be released unless you have any other holds at the jail. And once you're released, you must stay away from the Videodrome at 517 North Highland Avenue in Northeast Atlanta. Thank you.
And I don't want to interrupt you, Judge, but we're ready on position 3. We'll be in arraignment only.
Position 3,
23, Your Honor.
23. We are going back to Mr.
Philip.
Phillips, and he was
Philip.
let's try to find him on our screen. He's in courtroom 2, correct?
Correct, Judge.
All right. Mr. Phillips, we began this case with the intent to arraign it, in other words, to accept a non-guilty plea. This is resuming with 20 COB 000235. Oh, no, sorry, this was a non-negotiated plea hearing. And I was accepting the state's recommendation that he be sentenced to probation to complete 12 weeks of anger management and to stay away from the J&J grocery store. All right, and he will also have additional time to serve at the jail, which would be an additional 37 days.
And Mr. Sandy is not accepting that plea from the state judge. We're going to just arraign his case and request a jury trial.
All right. So, Mr. Sandy Phillip, if you've decided to enter a not guilty plea, do you waive a reading of the accusation, Ms. Helen?
I do, Judge.
And Mr. Phillips, if you decide to have a trial in this matter, upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right, that concludes the case.
I'm also ready on position 15, Judge.
All right.
Judge, I just wanted to give this court some information from Mr. Oscar. I do hear the history of being a multi-state offender, but I spoke to Mr. Oscar. Those were at least 10 years ago, and he's done his best to stay out of any type of arrest or trouble since then, Judge. Again, I wanted to say that he volunteers for the Atlanta Mission Christian program. And so we are looking for that community service. Even if it's more than 20, he cannot afford the anger management programs. I believe they may be $60 or more, and he's not able to afford those. He does not want any contact with Mr. Stone and agrees to stay from the 160, Judge. But he's not able to do the anger management.
All right. Ms. Harrison, could you give me any convictions that Mr. Johnson's had for any battery or any kind of violent offense?
One moment.
And is it true that his last conviction was 10 years ago?
I'm showing a 2017 and 2016 arrests in Nevada. This position is not listed. One which is sale or transport of Schedule 1 or 2 controlled substance.
And Your Honor, I have most of these written down if you would like me to give you the quick
Okay, yeah,
overview.
please do. Go ahead. That's all right, Ms. Harrison. Ms. Taylor, if you have it at your fingertips, please go ahead.
Sure. He has a battery family violence charge from 2013 out of Illinois, a battery family violence charge 2006 out of Illinois. I'm sorry, I think I said 2013 in the first one. It was 2003. A violating an extradition act in 2009 out of Illinois. Assault and causing bodily injury or to a family member from 2011. That was a felony out of Texas. He has evading arrest 2013 in Texas. He has a assault domestic violence 2005 out of Tennessee, an evading arrest 2005 out of Tennessee, a disorderly conduct 2018 out of Georgia. He has a battery on a firefighter from 2019 with no disposition out of Florida, a criminal trespass from 2014 from Washington, and an out-of-county warrant from that state. He also has an open DUI from Gwinnett from 7/22/22.
All right, thank you. All right, Mr. Johnson, I am still convinced that that I'm going to accept the state's recommendation. Ms. Helen, does your client want to proceed or would you like to be arraigned?
He would like to proceed, Judge. I spoke to him. He stated he would accept the 6 anger management and figure out some way to do those.
All right. I'm going to waive his probation fees up to through the end of March 2023. So he has the next few months to complete the anger management classes at his expense. This is 6 weeks. So end of March 2023 is more than 6 weeks for him to get employment, get funding, and complete the 6 week of anger management classes. And he will be on active probation at all times. There is no non-reporting. Mr. Johnson, do you still want to proceed with the plea offer?
No. I got no choice.
I'm sorry, I didn't understand what you just said.
Your Honor. Yes.
Okay. Miss Helen, do you stipulate to the factual basis, venue, and ID for this battery charge from October 28th?
I do, Your Honor.
All right. Mr. Johnson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, thank you. You may lower your hand. Have you consumed any medication or alcohol recently?
No.
And have you understood your attorney's explanations?
Yes.
And are you satisfied with your attorney's representation?
Yes.
If you decide to move forward with this plea offer, you do understand that you have additional time to serve at the Fulton County Jail, which is actually 1 day.
Yes.
All right. And once you're released, you must report to probation by next Thursday. Is anyone forcing you or inducing you to take this plea offer?
No.
Repeat.
No.
All right. And in taking this plea offer, you would have to waive and give up your constitutional right to a trial in front of a judge or a jury, to have the assistance of counsel so that you could put your mask back on above your nose. Thank you. To confront your accuser, examine witnesses, have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of battery from October 28, 2022?
Guilty, I guess.
I'm not accepting that plea offer if you're just guessing.
Oh, guilty. No.
Which one is it?
Guilty.
I accept your guilty plea. Your sentence is 12 months to serve 30 days, credit for time served 13 days. You have 1 more day left to serve at the Fulton County Jail. Upon being released, you must report to your probation officer next Thursday at 132 Mitchell Street in downtown Atlanta. You will be placed on probation. I will waive your probation fees from now until the end of March 2023. After which you will then start paying probation fees from April 1st, 2023 onwards. While you're on probation, you must complete 6 weeks of anger management classes at your expense and have no contact with Chester Stone, and stay away from the Circle K gas station at 160 Ted Turner Drive in Atlanta, Georgia. Thank you.
Judge, I have position 3 and 4 here.
Thank you. Is Mr. McLean concluded his conversation with Mr. Alvarez?
He's still in the hallway, Judge.
No, he's still talking to him, Your Honor.
I am ready on my last position if Mr. Van Sickle is available.
Mr. Van Sickle needs to talk to you again, Ms. Helen. Okay. You ready? Yeah, I'm ready. He said forget it. He's ready. Come on. This will be position number 28, Mr. Van Sickle.
All right, thank you. This is State versus Christopher Van Sickle, accused of reckless conduct from October 27, 2022. Mr. Van Sickle, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. Your case number is 22 CR 007-405C. This is going to be an arraignment and a possible bond modification. Do you waive a reading of the accusation, Ms. Helen?
I do, Judge.
All right. Mr. Van Sickle, you've been accused of the misdemeanor offense of reckless conduct. You are presumed innocent of this charge until the case goes to trial. That would be upon your entry of a not guilty plea. At the time of the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty, Your Honor.
Your case has been arraigned and there's going to be further notice for trial. With regards to your bond modification, Ms. Helen, you may proceed.
Yes, Judge, this is a bond hearing today for Mr. Van Sickle. And so I want to give some information about him today. He is 45 years old. He is a lifetime resident of Georgia. His mom has been in Sandy Springs for the last 30 years. Sister and stepdad are in Buckhead, have been there for the last several years. Again, he's a lifetime resident. So he was born at Northside Hospital, went to George Walton High School. He has 2 degrees from Ole Miss in history and anthropology. And I really want to get into this because I want to thank him for his service. He is a medically retired Marine. He is a combat veteran, Judge, as well. And all of that, he is also part of the Safety Net Recovery Residence Program, men living or men in recovery, Judge. He attends 2 different doctor visits for a Dr. Collins and a Dr. Casarella for medication and for physical therapy. Twice, 2 times a month. He has those appointments, and those appointments are going to be this month. He is afraid he's going to miss those appointments for his medication, judges for his physical recovery. But I also want to get into where else he volunteers at. Metro Atlanta Recovery Residence as well, Judge. He's done that for 7 years. That is a nonprofit as well, Judge. From not only the PTSD, the combat Marine veteran history, he was hit 11 years ago, went through the windshield after a drunk driver hit him, Judge. So that's also where the medication comes in. That's also where the physical therapy comes in. He takes medication for a brain injury as well, Judge. So Mr. Van Sickle is doing the best that he can, has a lot of great things about him. So let's get into the Ayala factors, Judge. I don't believe he's a danger to the community. He is volunteering. This is a retired combat veteran. This is not a person who's a danger to our community here in Georgia, Judge. I do believe he has strong family ties. He's not going to abscond or go to another state. He is going to remain here and come to all court dates. I don't believe he's going to have another reckless conduct or a violent charge like this. I don't believe he has violent charges in his history specifically like this. The only thing that we did speak to as far as in his history, he successfully completed a first offenders where he completed that program with those charges, Judge. So it does mention a firearm, but he completed that program. He completed that first offenders. Other than that, I don't believe that he has a violent, long-standing history. I also asked pretrial to read his history if they have time.
Ms. Harrison?
7 cycles. Last arrest was in December of 2019. One moment, I'm sorry. It was 2014. That was driving while license suspended in Gwinnett. It was a misdemeanor conviction. He has the first offenders that's already been mentioned, and a Clayton County theft by shoplifting, no disposition listed, and a 1996 simple battery, no disposition listed.
And Judge, I just want to also state going to the allegations of this case. It said that the officer charged it with reckless when Mr. Van Sinkle did not call the police. He actually went over and spoke to the neighbor, said, "I am so sorry. This was a complete accident," with a novelty .22 caliber gun. There was a shell casing found in that person's apartment, but Mr. Van Sinkle did make contact with that neighbor and also called the leasing office. And I just want to reiterate, he actually was put out of that location, that leasing office. So he has no contact with that neighbor or is even allowed to go back to that property, Judge. Also, I want to say he is involved in the Veterans Hospital, VA, for the last 20 years, Judge, getting medication. And he's not receiving that medication in the jail, Judge, and it's definitely having effect on his physical state, Judge. So we are asking for a bond of a signature bond in the same amount. He does not have the history. I don't believe he's a danger to our community. I don't believe he's going to get arrested again. And I don't believe he's going to abscond. So we are asking for that signature bond. If you feel that he isn't eligible for that signature bond, we're asking for a bond modification no more than $1,500 for this charge. Thank you, Judge.
Ms. Sari?
Yes, Your Honor. In this case, the victim, whose name is Benjamin Vale, he is on the Zoom call. He was sleeping in his bedroom at home when he heard a loud noise that morning. And then when he woke up, Your Honor, he noticed that there was a bullet hole near the headboard of his wall. And as the defense has stated, it did come from the defendant's home. The officers actually spoke with the victim and the defendant. The defendant stated that his gun accidentally discharged. However, he never called the police, Your Honor. He did not go to the victim's home to check. He did not report this incident at all. Your Honor, we've heard from pretrial regarding the history. I would like to note this defendant's reckless behavior. It does go back to the 90s with a DUI. He was found guilty of that. That DUI also resulted in a hit and run incident that was null-prossed. In 2011, he was arrested for carrying a weapon at a public gathering and possession of a firearm during the commission of a crime or attempt commission of a crime. That is the charge where he accepted the First Offender Act. And as we've heard, the driving while license suspended NOLO conviction. Your Honor, so he does present a significant danger to the community. He did not check on the victim, did not call 911. He knew that his gun went off and did not take the proper measures. The state's recommendation is for the bond to remain as set. And the defense is correct. He's not able to go back to the incident location. We're going to ask for no contact with the victim.
All right.
Understood, Judge. I just want to add a couple things. The .22 caliber was given to the police when they showed up. He gave that to them immediately. He called the leasing office, who then put him out of that location. And he did speak to that neighbor saying, "Hey, I am absolutely sorry. And that was a complete accident." So, Judge, we are asking for that.
Well, let's see. Mr. Benjamin Bale, if you'd like to unmute and start your video, please. All right, Mr. Vale, all right, my name is Judge Law, and may I place you under oath?
Yes,
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
yes, I do.
All right, the allegations, you may put your hand down, sir. You may put your hand down. Okay, might be. Mr. Vale, the allegation is that you live next door to the accused, Mr. Christopher Van Sickle, is that correct?
That is correct.
All right, and this allegedly occurred on or about near midnight, 12:30 a.m.?
That is correct.
All right, and what were you doing at that time?
I was laying down in my bed,
Okay,
and like they said, the bullet went through my wall about 18 inches from my headboard.
so it didn't hit your headboard, but it was near your headboard?
Yes, ma'am.
Okay, and can you tell me what happened after you saw the, after that bullet came into your apartment?
I can. So it was around 12 midnight. I didn't go over to his apartment to knock on the door. I didn't call the police. To be honest, I wasn't really sure what was going on over there. I waited until the next morning and I went right to the leasing office. They didn't know about anything. So I don't know what story he's saying that he called the leasing office. And also, he did not come up to me the next morning and say anything. In fact, I saw him smoking a cigarette on his patio. It was around 9:55 in the morning. And I went over and I looked at him and he looked at me and said, "How's it going?" He definitely did not apologize at first for shooting the bullet. In fact, when I confronted him and said, there's a hole between our wall, he immediately looked at me and said, "Oh, I didn't know it went through the wall." So he knew it went off. He definitely never apologized to me. In fact, he begged me not to call the police and begged me not to call the apartment complex because I've had issues with this gentleman before. It was almost a month ago, September 29th. He was playing music very loudly on a Thursday morning, which is ironic because this incident also happened on a Thursday morning, but it was 5:30 in the morning. I didn't call the police then. I didn't call the apartment complex then. I didn't know who he was. I simply walked over to his apartment at 5:30 in the morning and I knocked on his door and I asked him, "Can you lower the music down?" At that point, he said, "I appreciate you coming over, knocking on my door, not calling on the police." But he also did tell me, I don't need to listen to you. He told me that if he wants to play his music as loud as he can, he's more than welcome to do that, which I thought was very strange for 5:30 in the morning. And then also one thing I do want to say is the first time I did meet him, he said that he was lucky he didn't shoot me. I guess me walking over to his apartment on a Thursday morning, 5:30, asking him to lower the music down was enough warrant for him to say that I'm lucky that he didn't want to shoot me. So again, I just want to say he never apologized. In fact, he begged me not to call the police. So I don't know where the story is coming from that he called the leasing office and that he also apologized. He knew that he shot that gun off. He knew that gun went off and he admitted to me saying he didn't think it went through a wall. For someone who's been in the military as long as he says he does, I can't imagine a gun was misfired. And if it was misfired, Your Honor, what is he doing with the gun at 12:30 at night on a Thursday? What is he doing playing with it? There's no reason to play with the gun that late. And Your Honor, that's all I have to say. Thank you.
Thank you. Or anything else, Ms. Sari?
Your Honor, we would just ask you to take the victim's statements into account when making your ruling.
All right, Ms. Helen?
Yes, Judge, I just want to reiterate the point that the testimony did state it did hit a headboard, that it went through a wall, Judge.
All right, courtroom 2, please unmute. Mr. Van Sickle, this is going to boil down to he said. But what's more important also is that whatever you say, your statements can and will be used against you.
Yes, ma'am.
And Mr. Van Sickle, I kind of advise you not to say anything to the judge. If you want to give me a call, we can talk, but I advise you not to say anything in this open courtroom right now.
Okay, I mean, I can talk to my attorney, but I just wanted to say that the last contact I had before I realized that what had happened was actually Benjamin Bale had come to my apartment and asked me to help him move furniture, which I did just because I wanted to help. And I never threatened to shoot him ever. I've never threatened to shoot any civilian in my life. So I don't know where that comes from. And there's a woman named Lori at the leasing office, and I did notify her that that had been accidentally discharged. So those are facts.
All right. Well, thank you for the fact that the firearm was discharged. The bond is set at $3,000. It doesn't mitigate the fact that there are now conflicting stories, and the series of events seems to be highly questionable as they come from the defendant. The bond is set at $3,000. This is also in compliance with the Ayala factors, given Mr. Van Sickle's criminal history record. And the allegations that he apparently he was not forthright about the sequence of events. So no further contact with Benjamin Bell. He is not to return to the entire apartment complex at 270 Summer Drive in Sandy Springs. And of course, no contact with Benjamin Bell includes 200 yards away from Mr. Bell. Do not communicate with him in any way, form, or manner. And the third condition is to surrender any and all firearms that Mr. Van Sickle possesses. They all must be surrendered to the local police authorities, and he is not allowed to possess any weapons, any firearms on his person, in his home, in any vehicle he occupies, or anywhere near him. Thank you.
Understood, Judge.
Thank you.
Courtroom 2, who do we have?
Position 8, Mr. Burke.
Good morning, Your Honor.
Good morning. Good morning. This is Cosma D. Burks, accused of fleeing and attempting to elude an officer, misdemeanor possession of marijuana, reckless driving, and willful obstruction of an officer from October 27, 2022. Mr. Burks, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. This is going to be a negotiated plea. So, Mr. Burks, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. All right, Mr. Taylor, what's the recommendation for Mr. Burks?
Yes, ma'am.
Yes, Your Honor, it's to plead to count 1 and count 3, and to null pros count 2 and 4. Plea to count 1, the fleeing and attempting to elude, it's 12 months probation, serve 18 days, credit for time served 14 days with the balance probated, $1,000 fine, 40 hours community service, and then the plea to count 3, which is reckless driving, 12 months probation to run concurrently with count 1, no moving violations while on probation. And we're null prosing count 2, marijuana possession less than an ounce, and count 4, willful obstruction.
All right, I'm so sorry. That was 12 months to serve how many days?
18 days,
Credit for time served 9 days?
14 days.
14 days, okay. 18 days, 14 days, all right. And then that was 40 hours of community service and an alcohol and drug evaluation?
I did not have alcohol and drug
I'm
evaluation.
so sorry. I literally was writing something down. Can you repeat the sentence? I do apologize. It's my bad.
Yes, Your Honor. Plea to count 1, fleeing and attempting to elude, 12 months probation, serve 18 days, credit for time served 14 days with the balance probated, $1,000 fine, 40 hours community service.
Okay, got it. And
Plea to count 3, reckless driving with a $300 fine, 12 months probation to run concurrently.
and no moving violations, right?
Correct.
Okay. Okay. Thank you. Sorry about that. Mr. McLean, does your client stipulate to the factual basis, venue, and ID for the 2 charges? And is he inclined to accept these terms?
Yes, Your Honor, he does so stipulate as to the 3 items, and he does ask the court to accept these terms as his own, as well as the state's.
Thank you. All right, okay. Mr. Burks, have you consumed any medication or alcohol recently?
No, ma'am, Your Honor.
And have you understood and are you satisfied with your attorney?
Yes, Your Honor.
If you decide to take this plea offer, you do understand that you'll be placed on probation to pay off at least $1,300 in fines.
Yes, Your Honor.
Okay, and do 40 hours of community service.
Yes, Your Honor.
All right. And is anyone forcing you to accept these terms?
No, Your Honor.
If you decide to take this plea offer, you would have to give up your right to a trial, to confront your accuser, to be able to challenge the state's evidence, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of fleeing and attempting to elude a police officer and reckless driving?
Guilty, Your Honor.
On the fleeing and attempting to elude, your sentence is 12 months to serve 18 days, credit for time served 14 days. If you have no other cases holding you at the jail, you should be released within 24 hours. Once you're released, you must report to probation next Thursday on November 17th before 3 p.m. at 132 Mitchell Street in downtown Atlanta, Fulton County. While you're on probation, you need to pay off $1,000 fine, complete 40 hours of voluntary community service at any nonprofit agency that is not a school and not a religious organization. You will also need to, with regards to the second count, the sentence will run concurrent, except you need to pay off an additional $300 fine and not commit any further traffic moving violations. Understood?
Yes, Your Honor.
All right. So with regards to these charges, I will waive your probation fees up to and including March of 2023, but after that you will continue to report to probation. Understood?
Yes, Your Honor.
So you'll need to start paying probation fees from March 1st, 2023 onwards.
Yes, Your Honor.
All right. Thank you.
Good morning, Your Honor. Can we come to stop annex for position number 1 on the SAP calendar?
Okay. Mr. McLean, are we ready with the interpreter case?
Yeah, he's right here, Your Honor.
All right.
No, really, that's just an announcement for me if Your Honor is ready.
Go, okay, just one second, Ms. Lee. I'll be right with you, South Annex.
Yes, ma'am.
Do you solemnly swear and affirm that the translation you provide will be a true and accurate interpretation with no changes or embellishments?
I do.
Thank you. All right, we are addressing State versus Joel Alvarez Romero, case number 22 CR 007-424H.
Estamos hablando del caso de la Fiscalía Estatal contra José Álvarez Romero, el número de caso 22CR007424H.
Mr. Alvarez, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean.
Señor Romero, usted tiene el derecho a permanecer callado. Cualquier cosa que diga usted se puede usar y será usado en su contra. Usted tiene derecho a tener un abogado que lo represente, y aquí está el señor McLean representándolo a usted.
You are accused of discharging a firearm on or near a public highway, reckless conduct, and carrying a weapon or long gun in unauthorized locations.
Porque a usted se le acusa por haber disparado un arma cerca de una carretera pública, por tener una conducta, manejar temerariamente, y también por llevar consigo una arma sin tener los requisitos para poder llevar esta arma de fuego legalmente.
All right, Mr. McLean, what's your announcement?
Your Honor, I've spoken with him preliminarily, and we need further discussion. There is a hold which will not cause our delay in my asking for a reset any problems for Mr. Alvarez.
And how far out am I resetting this case? Is it 1 week?
I think 2 weeks is okay.
All right, that would put us in the Thanksgiving. We don't have SAP on the 24th, so that will be December 1st.
That's fine.
This case is reset December 1st.
Este caso lo van a posponer y lo van a tener para el 1 de diciembre.
Does Mr. Alvarez understand why his attorney is resetting the case for further?
Señor Álvarez, ¿usted entiende por qué su abogado pospuso el caso para más adelante? ¿Entiende las razones por las cuales vamos a hacer esto?
No.
No.
All right,
We-
Mr. Go
We could
ahead.
do another phone call, Your Honor, because we did go over it,
I
but
know.
that'd be fine.
I'm just going to reiterate, Ms. Lane, if you can explain, his attorney needs to have further time to investigate and research the issues in this case.
Señor Álvarez, la razón por la cual es porque su abogado necesita investigar y aprender más sobre este caso, sobre los asuntos que tienen pertinencia con su caso. Necesita más tiempo para investigar su caso.
Okay.
Okay.
All right, thank you. Mr. McLean, you may explain to him in detail when you go see him at the jail.
Right. I told him, Your Honor, I would attempt to do that tomorrow and within the next couple of days, if not tomorrow.
All right, Ms. Lee?
Okay, que su abogado le dijo a usted que va a tratar de irlo a ver mañana o en los próximos par de días, en los siguientes días, para que vaya a visitarlo a la cárcel.
Your Honor, after court, may I inquire of the court whether there is any practical or administrative assistance in having the interpreter able to get on the phone while I'm with him at the jail?
You would have to request that directly from your office to the interpreter services.
Very good. Thank you.
All right, thank you.
Y van a asegurarse que tenga un intérprete. El abogado va a pedir un pedido para que vaya un intérprete con él, ya sea por teléfono o en persona.
All right, thank you.
Okay. Your Honor, do you have any more cases that need an interpreter, or?
I
Do you
don't
need
know,
any-
Miss Helen, do you have any cases in which you request a Spanish interpreter?
No, Judge.
All right, no, thank you, Miss Lee, I appreciate it.
Very well. You're very welcome and have a good day.
You too, thank you.
Thank you.
Mr. McLean, we are ready to proceed with position 1 at the South Annex.
Yes, Your Honor, that case is ready for a negotiated plea.
This is Sheila Adkins, case number 22 CR 007-420J. Ms. Adkins is accused of simple battery from October 28, 2022. Ms. Adkins, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. This is going to be a negotiated plea. May I place you under oath, Ms. Adkins?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Mr. Taylor, what's the plea offer?
Yes, Your Honor, it's plead count 1, simple battery, 12 months probation, served 26 days, credit for time served 13 days, with the balance probated. She's to have a 6-week anger management course, no contact with the victim, Michael Kemp. And upon completion of the anger management course, probation can terminate.
Coming, okay. Mr. McLean, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
Yes, Your Honor, we do so stipulate, and she does accept those terms.
All right. Ms. Atkins, have you consumed any medication or alcohol lately?
No, for medication, I take for seizures.
Okay, and if you've taken them, have you still been able to understand the proceedings so far?
The proceedings like what?
Have you been able to understand what's going on so far?
Oh, yes, ma'am. Yes,
All
ma'am.
right. And you are represented by Attorney McLean. Are you satisfied with this representation?
Yes, ma'am.
And is anyone forcing you or inducing you to take a plea offer today?
No, ma'am.
If you decide to take this plea offer, has your attorney gone over all the rights that you will be giving up in order to plead guilty today?
Yes, ma'am.
And how do you plead to 1 count of simple battery?
Guilty.
Your sentence is 12 months to serve 26 days, credit for time served 13 days. Your jail time at the jail is concluded for this case. If you have no other holds, you should be released within 24 hours and you'll be placed on probation. You must report to the probation office next Thursday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While on probation, you must complete 6 weeks of anger management classes at your expense and have no contact with Michael Kemp. I will waive your probation fees from now until the end of March 2023. If you have completed your 6 classes before the end of March 2023, your probation will terminate. Understood?
Yes, ma'am.
Thank you. All right, courtroom 2, who do we have?
Our last one, Mr. Derek Bailey, position 3 and position 4.
All right, thank you. And these are also going to be negotiated pleas. Mr. Taylor, is this going to be a global offer for both cases?
Your Honor, the state's intention is that the failure to appear will be satisfied by a plea to count 3,
Yes,
or sorry, case 3.
So you're going to null pros position 4?
Yes, Your Honor.
Okay, position 4 is going to be null pro. Okay, Mr. Bailey, Derek Bailey, you have 2 cases before us. One of the cases is going to be closed as the state is not going to prosecute you on that matter. And that will be case number 22 FTA 000017 for failure to appear on September 19th, and the warrant was issued September 19, 2022. So that leaves us with 1 case against you, which is 21 CR 005485J, in which Mr. Derek Bailey was accused of a seatbelt violation, adult, and driving without a valid license from October 12, 2021. You've been advised of your right to remain silent, and your attorney is Mr. McLean. May I place you under oath since this is a negotiated plea?
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Bailey, let's hear from the prosecutor first. Mr. Taylor?
Yes, Your Honor, the plea recommendation for position 3 is to plead to counts 1 and 2, seatbelt violation and driving without a valid license. For 12 months probation, serve 6 days, credit for time served 6 days, with the balance suspended.
Mr. McLean, does your client stipulate to the factual basis, venue, and ID and accept these terms?
Yes, Your Honor. He does accept those terms, and he does stipulate to venue, ID, and factual basis.
Mr. Bailey, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood your attorney? Are you satisfied with his representation?
Yes, ma'am.
If you decide to take this plea offer, you do understand that you would be giving up your right to a trial, to go back to court and challenge the charges, to have the assistance of counsel to represent you, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of seatbelt violation and 1 count of driving without a valid license?
Guilty, ma'am.
All right, your sentence is 12 months to serve 6 days, credit for time served 6 days, balance suspended. That concludes your case. Thank you.
Oh, and Your Honor, while I haven't looked at it recently in writing up the sentence, the court may find that the seatbelt violation has to do with a $15 fine if it's a first offense or something along those lines, that the other matter would be the time served.
Which other matter?
Let's see, let me go back to that. let me take a second. To look at that.
If we're still talking about Bailey, the second case, position 4, is null pros.
Right, the driving without a valid license would be the thing that involves the time served. On counts 1 and 2 on position 3.
Yeah.
It would be the driving without a license that would carry the time served, because I think, if I'm correct, is this just by memory? I think that the maximum sentence on first time seatbelt is $15 fine.
Oh, okay. Well, that's where I thought it was, but I think Mr. Taylor made it a global offer for both charges.
Right.
So did you want it amended accordingly?
Well, I'm just saying that when Your Honor writes the sentence up, probably count 1 would be the fine, and count 2 would be the thing that mentioned the 6 days in jail.
Right. Ms. Strom, what we're going to do, Mr. Taylor and Mr. McLean is correct. On the seatbelt violation, I'm going to make it a $15 fine, suspended, and the driving without a valid license will be the time served fee. All right, that concludes the case. Thank you.
Interestingly, Your Honor, once there was a US Supreme Court case about something similar, and a person can go to jail for not going to court on a $15 fine, but they can't go to jail on the $15 fine itself.
Well, no comment right there. Okay, moving on. Thank you, Mr. Bailey. Your case is concluded. I
Your
think
Honor?
that was the last case in courtroom 2.
That's correct.
Yes, Ms. Fall?
Yes, I am here with Chief Allaby, and we wanted to speak with Your Honor in a breakout with PD McLean, PD Helen, and Mr. Walker. With the
I
SG.
also believe Mr. Howard, there he is. He wants to
All right,
talk to.
we will do that after we conclude it with the calendars. I still have a few more. Okay, SAP calendar, I got an add-on.
I think they're DVs, right, Judge? We have a DV calendar.
Yes, we do. Let me finish my DeMarcus Royalston. This was a show cause hearing.
Right, that is a hearing that Miss Clarissa St. Flex is handling and Miss Marcia Francis.
Is this the one that we had?
They're also in court. Would you like me to text them?
No,
Would you like me to
DeMarcus
text-
Royalston is here. Yeah.
Right. his
Yes, ma'am,
attorney's
I'm
not
right here.
though, Your Honor.
Miss
So I can
Sanchez
text her.
She should be here. She had just called me and told me to change my name in the screening.
All right.
I could text those attorneys that's handling that matter, and then
Okay.
we can break out if you don't mind.
And Judge, I'm ready for Deja, and I believe she's present here.
Okay. So the SAP calendar is concluded. I've got one add-on case for Mr. Royalston to address. And I've got a competency calendar, which I'll address in a breakout. But let's move on to my DV bench warrant calendar. So let's see.
We have a Mr. Lowe as well.
Mr. Who?
No, she got some.
All right, let me just start with position 5 on the bench warrant calendar. This is 20 CR 0000985B. Ms. Deja Robinson is accused of battery, cruelty in the 3rd degree, and criminal trespass from January 27, 2020. And Ms. Robinson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. On November 3rd, a bond forfeiture was issued in which Ms. Deja Robinson did not appear in court on October 17th before Judge Porter. And she has since then requested a set aside of the bond forfeiture and to reinstate her bond. So yes, Ms. Helen.
Yes, Judge. So I do have Miss Deja Robinson, who's appearing on Zoom. I am looking on Odyssey. There is a return to sender that has been scanned in October the 11th of 2022. Prior to that, I don't see any other return to senders. When I went and spoke to Deja, she had moved from that 3,000, I believe it's a Continental Colony Parkway, E83, Atlanta, Georgia, about 3 years ago. I believe that the incident date alleged here is about 3 years old. So she wasn't contacted by the clerk's office at all about a notice until October, but she had already moved from that location, Judge. I do believe it's this court's policy that the first time FTA, there is a set aside, but I wanted to go into a little bit more. She was continuously reporting for the last 3 years, but had not received that notice. I don't believe she had the information that to update that address, she has to do it in person. She can't call over the phone. So Judge, she didn't receive that notice whatsoever, but she has been checking in for the last 3 years with Bruce Romanoff. about this particular case. So she was also notified by Bruce Romanoff that there was a failure to appear. So Judge, this is just a clerical error of not updating this address, but she had no idea to update it in person. But she had been contacting the court to keep up with this case, Judge. We are asking for that one-time set aside for Miss Deja. She also is a proud mother of one son. She is not currently working, Judge, but to have herself turn herself in for this failure to appear would be devastating right now for her. She's also looking to get her GED. She is looking for employment, Judge. So we are asking for that bench warrant to be set aside.
When did she move?
Judge, sometime 3 years ago. She said the same year the incident happened, I believe it was
Okay,
2020.
but she did not inform the court of a change of address.
No, Judge, but she had been checking in with Mr. Romanoff.
Okay. Mr. Walker?
Yes, Your Honor. I'm reviewing the defendant's criminal history. I see that she has a previous, albeit it was dead docketed, she has a previous aggravated assault with the same exact victim. And I say that to say that this defendant is no stranger to the criminal justice system. This is, in fact, her second case with the same exact victim. This time it is in state court. However, she had an FTA, and from my understanding, she had a pretrial release bond. She was already been given the benefit of a signature bond. And we're asking that the bench warrant remain. It's the defendant's responsibility to update their address if they were to move. And I'm of the opinion if she's been checking in with pretrial, she probably would know what her court date was. But that's still not an excuse. It's upon the defendant to update the court or the clerk with their address. She did not do that. So if she did not receive notice, it's of her own doing. So she's already been given a pretrial release bond. I think to now sit aside or give her another signature bond would be inappropriate. And I'm asking that she's remanded into custody and those pretrial release bonds are converted into surety bonds.
Yes, Judge, I don't believe that is inappropriate. Specifically, again, she has updated her address with the clerk's office, November the 3rd of 2022. I believe you do see that document on Odyssey. We have a good email address. We have a good address. We have Ms. Robinson appearing on Zoom. We are asking for that bench warrant to be set aside in this case, Judge.
So is the Camp Creek Parkway her current address?
That is, and it'll be valid for the next 2 years. I've checked with Ms. Deja.
Okay, Ms. Harrison, has there been any involvement with the law since February 2020?
No, Judge, she's been in compliance.
Okay, all right. I'm going to set aside the bench warrant and reinstate her pretrial bond. She will continue to report to pretrial and make sure she has no contact with the victim and to comply with all the other conditions. Ms. Robinson, it's your responsibility to come down to the courthouse, just like you did when you filed a motion to set aside, to update any changes in your address or your contact information with the court. So we're going to let this one slide. Although, let me be very clear, it is not the policy of the judicial officers or the state court to let the first time for a first failure to appear, to let it slide. We're always going to look at the factors before we grant a set aside. So let me just be very clear about that. Okay. Ms. Helen, please go ahead and submit the proposed order setting aside the bond forfeiture issued on November 3rd, 2022, reinstating her signature bond. I believe it was $3,500, and that she needs to continue to report to pretrial in accordance with the formal bond order.
Understood, Judge.
I'm just going to take a, we're going to take our next bench warrant case. All right, the next bench warrant case I got a couple of folks over here. Is Miss St. Flex here now, or who are the prosecutor and the PD in the Royalston case?
It is Miss St. Flex and ASG Francis. I have texted them. I believe that they are on their way.
Okay, all right. Mr. Royalston, please hold until the attorneys appear. Okay, I have Shakima Hunt.
Yes, ma'am.
Shakima Hunt. I do see her on screen somewhere. There she is. Okay.
Yes, I'm present.
All right. Miss Shakima Hunt is case 20 CR 005749Y. Ms. Hunt was accused of battery, substantial physical harm, 1 count of battery, and 4 separate counts of simple battery from March 26, 2020. Ms. Hunt, you have a right to remain silent. Anything you say in open court, statements can and will be used against you. You have a right to an attorney, and Ms.
Judge,
Hunt,
this is a conflict attorney case. Ms. Hunt is a co-defendant with Honesty Hunt, and we represent Honesty, so we won't be able to represent her. She'll have to be referred to the conflicts. And there's Ms. McLeod.
Good morning, Your Honor. I'm here on behalf of Ms. Hunt.
I appreciate it. Thank you, Ms. McLeod. So, Ms. Hunt, that is your attorney. Do you see her on the screen?
Yes, ma'am.
All right. Ms. McLeod is representing Ms. Hunt. Ms. Hunt was supposed to appear in court on, what was it, last Friday, November 4th, 2022. She was given 1 hour to show up at the Fulton County Courthouse. She assured the court that she would appear in 25 minutes. The court was there for well over 1 hour, and Ms. Hunt still had not appeared and still had not shown up to court. She appeared apparently at the clerk's office at 1:30 p.m., which is more than 2 hours since the court had directed her to appear in person. For her failure to appear, a bench warrant was issued for her failure to comply. So, Ms. McLeod?
Yes, Your Honor. I haven't had the opportunity to speak with her yet,
Okay.
Your Honor.
Let's go
so
ahead.
I can't really speak as to what the situation was, which prevented her from showing up on time. I did send an email asking for
I'm telling you this from personal knowledge because I was the judge where she did not appear in court. When I ordered her specifically, I gave her 60 minutes. She said no, and she said she would be there in 30, and she did not. So that's the situation. So I'm going to put you in a breakout room.
Yes, Your Honor. I would like to be able to speak with her.
All right. Mr. Jordan, if you could place Shakima Hunt and attorney Maureen McLeod in a breakout room, please.
Thank you, Your Honor.
Ms. Hunt, you will see a message on the screen to join a breakout room with your attorney. All right. Is Dontavius Lowe, L-O-W-E, present? Dontavius Lowe, he's got 3 cases with us, 2, 3, and 4. All right, Dontavius Lowe has failed to appear for the bench warrant calendar. He did file a request to set aside the bond forfeiture. He has failed to do so, so the request to set aside the bond forfeiture is denied.
Your Honor, on Mr. Lowe? Are we on Mr. Lowe yet?
Oh, are you the attorney for Mr. Lowe?
Well, I just spoke to him on the phone, Your Honor. He has not yet hired a private attorney. We do have to since he's not in jail, we do have to qualify them at this point. That's a policy of ours. So I'm going to take an application from him.
I'm just curious why he hasn't shown up, because he did file the bond forfeiture in person.
Right. He told me he was on Zoom. I was just.
He is on Zoom?
He did appear earlier, Judge.
Well, then where is he now? His calendar wasn't until 11 o'clock. It's only 11:20.
Judge, he may be coming back. He probably got kicked out because he was on his phone.
Right. When I told him to call me, when I told him to phone me, he probably kicked himself off the Zoom. I'm sorry.
All right. If you have his number, please text him and let him know that his bond forfeiture is going to be denied unless he gets back.
He just logged on.
Hey, I'm here. I'm here.
Who's here?
Dontavius Lowe.
All right, Mr. Lowe, you need to stop moving. You need to go into a room with better lighting because we cannot see you.
Okay.
I apologize, Judge. Is Ms. Robinson excused?
Yes, she is. I told her she was excused. So
thank you, Judge.
All right, Dontavius Lowe, where is he?
I'm right here.
Okay, now you have to stop moving. You have to stop moving. All right. All right, Mr. Dontavius Lowe, you've got a bond forfeiture from 3 separate cases. Let me check with all 3. You failed to appear before Judge Besson on October 31st.
Right, Your Honor, all three were October 31st in courtroom 3D together.
Okay, all right. And Mr. Lowe, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. And I believe that you were supposed to hire a private attorney. You have not been qualified by the Public Defender's Office. So at the present time, I'm just going to assume that you are representing yourself. Is that correct?
Well,
Yes, ma'am.
he did explain to me, Your Honor, the circumstances. I talked to him about the bar referral service, the mechanism where for $45 you get a consultation for a certain number of minutes and shop for a lawyer that way. And we discussed other ways of shopping for a lawyer. If he does qualify after I have him fill out the form, Your Honor, we'd be glad to represent him. He did want to go ahead and explain to the court what happened on that day he was trying to log on. Apparently it was virtual. Mr. Lowe, did you want to go ahead and?
Well, first of all, I just need to clarify one thing. The Public Defender's Office does not represent him. That's the first thing we're going to put on the record. The Public Defender's Office does not represent him.
Not yet, Your Honor. And it would, and if it pleases the court, we could ask to reset it so we could qualify him.
No. There's no resets. We've got a bond forfeiture.
Yes, and the state would object.
He's got, and these are three separate cases. Let me see what the other two.
That's correct, Your Honor. There are three separate cases against the same victim.
I'm sorry, I'm just trying to see. These are all before Judge Besson.
Correct.
He did not appear on October 30th. Katrina transfer. Okay. And the third case. All right, Mr. Lowe, I do not know why you did not speak to the Public Defender's Office a lot earlier, and I do not understand why you do not have a private attorney with you today. So I'm going to assume that you are representing yourself when you filled out that bond forfeiture set aside.
Yes, well, I didn't know I had to have an attorney.
You didn't know you had to have an attorney? You've got three open criminal cases against you. At what point did you decide you didn't need an attorney or didn't know?
I did.
You don't have one, you don't have two, you have three, all from different times. At what juncture did you realize that you needed an attorney or didn't? Hang on, Ms. Harrison, do you have a priors on Mr. Lowe?
Judge, I'm only showing two cycles.
Okay.
And he has three cases today, so it would be more than two.
Now, Your Honor, he was represented when he was in jail. I'm flipping through the papers here. It looks like he was represented by our office when he was in jail in months prior.
So, Mr. McLean, are you taking the position now that this is a continuing representation?
Well, let me think about that.
All right, okay, because before you chime in, you either have to represent him or you don't represent him. That is black and white. There's no gray area there.
Okay, Mr. Howard is texting me, and in the breakout session, Your Honor, he would like to address this to the court.
Judge, this GCIC was ran today. and it's just two cycles.
No, hang on, folks. Hang on. No, we're not going to address this situation like that. All right, Mr. Lowe,
Yes, ma'am.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
I've already advised you of a right to remain silent. I've advised you on your right to an attorney. You have still not spoken to the Public Defender's Office to qualify for their services, so they are not representing you right now. You have not hired an attorney. This is a situation where your bonds have been suspended, have been forfeited because you did not appear in court on October 31st, 2022 before Judge Besson. Do you want to tell me why you did not appear?
Yes, ma'am, because actually on that day, I was having problems logging into the virtual court. So I called down to the court to try to see, can I get in touch with someone to see what could I do? And I was calling and the lady was telling me she was going to refer me to some other number. And I never got in touch with anyone, but I kept calling back, trying to see what can I do.
So at any point on the 31st, did you come down to the courthouse?
No, ma'am.
Why not? That was your court date.
I didn't know I had to actually come down to the court.
All right. Okay. Ms. Sari?
Yes, Your Honor. The state's position is for the bench warrant to remain. As we know, the defendant does have 3 cases on the calendar today. They're all against the same victim. One case is a battery family violence. One case is a battery against a pregnant female. So, Your Honor, these are very serious allegations. This defendant does present a risk of intimidating this victim. They have children together, the multiple cases. He does present a risk of reoffending. These cases happen pretty much back to back, one in September of 2021 and the other 2 in December of 2021. Your Honor, he did go to the C calendar back in February. So the state's position is that the defendant had enough time to hire an attorney and he did make bond. So we are asking for that bench warrant to remain. Nothing further, Judge.
Do you have any rebuttal, Mr. Lowe? The state wants the warrant to be served and that you return back to jail. Do you have any questions or any rebuttal?
I was actually calling trying to see what can I do. So I was actually on the phone with the jail and everybody who I could get in touch with. So I'm trying to see, like, is there any, because I tried everything I could do. I went down to the courthouse.
Did you try calling an attorney, a private attorney, and seeing what were your options?
No, ma'am. When I got it, I called my bail bonding people. They told me to go to the courthouse. So I went
That's
down.
not what I asked you. I asked you, did you try hiring an attorney to represent you?
No, ma'am.
All right. I'm not going to set aside the bond forfeitures. You are going to come down to the Fulton County Jail and you're going to be booked in, and we're going to close out the 3 warrants, bench warrants from these 3 cases. I'm going to amend your bond to a signature bond through pretrial services, which means that all you're doing is coming down to the jail, being booked in, and then turning right around and being released on a signature bond. Do you understand?
Yes, ma'am.
All right. And once you're released on a signature bond, you're going to have new conditions to the bond. And I'll be doing the orders for these. All the other provisions are going to stay the same. You have to have no contact with the victim or victims. You have to stay away from the location, including the entire apartment complexes. I hope you're not at the same apartment complex, and I hope you're not in contact with any of the victims.
No, ma'am.
All right. No alcohol, no drugs, no weapons. And
No.
while you are out on a signature bond through pretrial, you will report to pretrial every month.
Okay.
And you will report to pretrial. If you fail to report, a warrant will be issued for your arrest. If you violate any of the conditions of the bond, you will be a bench warrant will issue. Now, while you're out on a signature bond through pretrial services, I want you to begin the domestic violence intervention program. You must begin those classes within 30 days from today.
Yes, ma'am.
So by the second time that you report to pretrial, you would have informed them that you are enrolled and begun your 6-month domestic violence classes, and those must be paid out of your own pocket.
Okay.
You have to report to today is Thursday, so you have to report. Officer Norris, courtroom 2. Sir? If he reports on Friday, how long would it take for him to be processed at booking and then be released on pretrial? Courtroom 2? All right, I'm not getting any feedback. All right, so Mr. Lowe?
Yes, ma'am.
You have to report to the Fulton County Jail before noon tomorrow.
Okay. Tomorrow.
Before noon tomorrow, which is November, oh no, hang on, tomorrow is November 11th. It should be open. The jail's open 24/7.
Okay.
All right, tomorrow is Veterans Day, so hopefully you are not working. It should be somewhat of a public holiday, so before noon tomorrow, you report to jail and I will have the orders issued. On position 2, on the simple battery is going to be 2,500. On the criminal trespass is 1,500. That's a $4,000 signature bond through pretrial services. On position 3, on the battery charge, that's 2,500. That's a signature bond through pretrial services. And on position 4, on the battery charge, that's a 2,500 signature bond through pretrial services. Mr. Lowe, if you violate any of the conditions of these bonds, your total bond next time is going to be $9,000. Do you understand?
Yes, ma'am.
All right. Now, the bonds that you've already paid for and made, those are all forfeited. Those are all gone. Do you understand?
Yes, ma'am.
All right. And one more thing. Once you are released from the jail, you can either go straight down to the public defender's office and speak to them to see if you qualify for their services, or use Mr. McLean's advice and do the state bar referral, or hire your own private attorney. If you choose to represent yourself, you are responsible for understanding how your legal decisions impact the facts of your case. Nobody else is going to advise you. So right now, it appears that you don't really know much about criminal defense. So I highly recommend that you exercise one of those other options.
Okay.
All right. Remember to report to the jail by noon tomorrow. Thank you. All right. So I think that takes care of Ms. McLeod. We are going to address Ms. Hunt's case. And Mr. Lowe, you're free to go. All right. Ms. McLeod, you may unmute your screen.
Yes, Your Honor.
All right. Yes. What would you?
I've had the opportunity to talk with my client, Your Honor. She tells me that on the 4th of November, what had happened was that she was called by the attorney representing her daughter and was told by that person that neither herself nor her daughter had to report in person. They could appear on Zoom.
Ms. McLeod, I've already got all that part where she had a big misunderstanding of whether she had to have conflict or direct attorney. I've already understood all that part. The only portion I'm concerned about is that she represented to the court, me, that she was going to show up in G33 at 160 Prior Street in 30 minutes. And it took more than 2.5 hours to show up.
Your Honor, what she tells me is that she was trying to tell the court that she needed some more time because she has a 4-year-old that she had to get ready. She also does not have a car, so she had to call Uber. So that was really the issue, trying to get her 4-year-old up, feeding him, getting ready to go, and waiting on the Uber.
Ms. McLeod, I'm not buying that argument. We are all mothers and we all have had to do that. So, especially in light of the fact that she represented to the court, she would be down in 30 minutes and we gave her well over an hour. So I'm still not buying that argument.
What she tells me is that she was trying to tell you that she needed more time.
I did.
All right, Mr. Walker.
If the state could speak on this matter, I understand that you ordered the defendant to show in person. That's probably because the defendant has already FTA'd 2 times before the last time she told the court that she was going to show up. I see an FTA in January of 2021. I see another one in October of 2021. And not only does that make 3 FTAs, on 10/14 of this year, she was rearrested on another violent incident, which includes reckless conduct and battery. That case number is 22 CR 006908Y. So while the defendant is avoiding her court dates, that's 3 FTAs I just stated, she's also racking up new violent offenses with the same parties. Honesty is the victim in the latest case, and I believe Honesty is the co-defendant in this case. So there seems to be a violent history. There seems to be a blatant disregard for the court's orders. You gave her more than an hour. I think you said she showed up 2 hours later, and that's after she already FTA'd twice. And to add insult to the injury, she was rearrested just last month with the same, well, this co-defendant is the victim in her latest case where she's charged with reckless conduct. She hit Honesty in a 1-year-old with a stick. And that's the basis of her latest case. So this is a violent offender, and she has shown and demonstrated to the court a blatant disregard to follow the court's orders. So we are asking for the bond to remain at sit on the bench warrant, and the defendant is remaining into custody.
All right, Ms. McLeod.
Yes, Your Honor. Even though she appeared late, she did appear. So there was an effort made to get there, Your Honor. So the prosecutor's statements that she is some kind of flight risk or a risk for not showing up, I don't think that's accurate. She did in fact show up. She was late, but she did show up. She's here today also. She has things that she's dealing with right now. She tells me she's unemployed. She's about to be evicted from her apartment. She doesn't know where she's gonna go with her 4-year-old child. So life is happening for Miss Hunt this time, but she's still trying to do what the court has asked her to do, and she has appeared today. So I would ask the court not to revoke her bond here, because she is here and she's not going to be going anywhere. She tells me she's trying to get employment, trying to find new accommodations. So things are pretty tough for her right now. And if the court revokes her bond, she's just gonna end up in jail. She doesn't have anyone to take care of her 4-year-old. And she's essentially going to be on the street with a 4-year-old.
And to add, I'm sorry, there's so many FTAs I lost count. I see one from 9/23 of this year also, she was supposed to show, and then we have one on 11/4, so that makes 4 total FTAs.
Well, the 11/4 was when she did not appear in court in time. She did appear via Zoom.
And then what about, I'm sorry, I just clicked off, but I saw one of September of this year. Yeah, 9/23/22 FTA per Odyssey. Do you see that, Your Honor?
Yes, the defendant was in the grocery store shopping during.
So, and then we have the 2 FTAs with Judge Edie. Then we have the latest case, when she was in the grocery store, that was 9/23. About 21 days later, she was rearrested on a reckless conduct and a battery with the same person. So while the defendant is blatantly not coming to court while she's enjoying the benefit of a signature bond at that, and I'm not sure if it was Your Honor who set the signature bond. I could look at that as well, but nonetheless, she's out and about grocery shopping, blatantly not coming to court, catching new violent cases with the same exact victims, and showing the court no regard for the court's orders. Her signature bond needs to be converted into a surety bond. The defendant needs to remand herself into custody. I mean, how many times do we get someone to show up to court? 4, 5, 6 times? This is her 4th. She has 4 FTAs.
On the 24th court. Your Honor, she is still here. Despite the FTAs, she's still here. She's here today. The incident on which she received this bond happened in 2020, and she's still here today. She's right here. She hasn't gone anywhere. Yes, we recognize that there have been incidents, but she has been dealing with some other things in her life. She has told me that she had to be dealing with the death of her grandmother and 2 recent evictions, and plus she's unemployed. This is a lot for someone to be dealing with.
This is due to the negligence of the kids, not me.
I didn't hear what the defendant said.
Yes, and
I'm not going to
if she
address
is
that.
put in jail now, Your Honor, her life it's going to severely impact her life. Her 4-year-old child, she and her 4-year-old child will essentially be on the street. And she is here. It's not like she's gone anywhere and cannot be found. She
And
is
I'm
still.
not showing up because I'm being negligent. It's just I have a lot going on. The 23rd, I did appear in court. I spoke with the judge that I'm speaking to now. It was my grandson's first birthday, and I expressed that to her. She told us to get to where we can sit still. I stayed in my car, and I waited to get joined into the chat. They never let me back in the chat. So they reset the court date to another day, which I did show up. I've been showing up ever since then. Yes.
I don't know what court date.
No, I'm ready to rule. I'm ready to rule. Ms. Hunt, I do appreciate your difficult situation, but I have to treat all defendants equally. And you have been very, very consistent about having one excuse after another for failure to appear in time, for failure to comply with the court's order. You do have a very cavalier disregard of court orders.
I do not.
And the worst part is that now, as a prosecutor has indicated that you picked up a second case against the same alleged victim.
With my daughter, this was a family matter. This was a altercation.
The bench warrant is not going to be set aside. You're going to report to the Fulton County Jail. And you're going to report by noon tomorrow to be booked in. Your signature bond is going to be revoked for failure to comply with the court's orders. And your new bonds are going to be set as follows.
But I did
battery causing substantial physical harm, that's going to be 500. The battery is 250. The each count of simple battery 3 to 6 is 250 each. That's a total of 1,500. It's a surety bond. No further contact with Miss Honesty.
I think there's one other victim, Your Honor. I'm sorry.
This is the only case I'm addressing with.
Well, I think
that was Rosalie Nina Darden.
Correct, Your Honor.
No contact with Rosalie Nina Darden. No alcohol, drugs, and weapons. Your next court date will be scheduled for the SAP calendar, and that would be November 17th, 2022. Ms. McLeod, you're put on notice that this case, you're traveling on November 17th.
I'm traveling on the 17th, Your Honor, but I believe there's going to be another calendar on the 18th.
Yeah.
If there is, I can attend that.
There is no SAP calendar on the 18th. Mr. Jordan, can we place her on the C calendar on the 18th?
Because I will be able to attend on the 18th, Your Honor.
I can, Judge. That's not a problem.
We will put on the C calendar November 18th at 2 p.m. Actually, I can actually put on the 15th with Judge Morrow. Is that all right, Ms. McLeod?
That's fine with me, Your Honor.
All right. If she makes the bond, then she will then she'll be further notice. Thank you.
Thank you, Your Honor. Your Honor, that concludes my business before the court today. May I be excused?
Yes, thank you.
Thank you.
All right, Ms. Hunt, Ms. McLeod, if you have a number, Please let Ms. Hunt know that she has to report to the jail by noon tomorrow, otherwise she will be arrested on these outstanding warrants.
Yes, Your Honor, I will let her know.
Thank you.
Miss Hunt, don't go away yet. I'm gonna send you my number in the chat.
Okay.
Thank you. All right. Courtroom 2, is that the competency calendar? Or is that another calendar?
Yes, Your Honor, that's position 10 and 11, Mr. Stafford.
I apologize, Judge. I believe that's all of my business today. Can I be excused?
Yes, Mr. McLean will have to go down the SAP calendar with you.
Yes,
once
I have that.
Okay,
Yep.
thank you.
Thank you.
As you're aware, Your Honor, the Competency calendar can take some time. If it's possible, we could do the breakout with Deputy Falk and Mr. Howard and Chief Allaby.
Hey, Mr. Walker, because I'm starting misdemeanor inside courtroom 2.
Yep, they have
So
their
yeah, that-
calendars too coming up.
Thank you.
Okay. All right. So
Sorry,
this is
Walker.
position 10 and 11?
Well,
Yes, Your Honor.
I guess what I was saying is it requires us to go into a breakout anyway, since it's the competency calendar.
So we're just going to do the breakout for competency. This is State versus Donald Stafford, 22 CR 004-389F. Mr. Stafford's accused of battery in that particular case.
I'm sorry, are we not going, we normally do the
We
competency
are. I'm just going to
calendar.
let him know what's going on.
Okay, I'm sorry.
Okay, June 23rd, 2022. And Mr. Stafford, you have a second case, 22 CR 004474F, in which you're accused of criminal trespass and obstruction of an officer from November 1st, 2021. The attorneys and I are going to be in a separate discussion room, so we will be with you shortly. Please remember that everyone in that courtroom, you have a right to remain silent. If you say anything, your statements can and will be used against you. You have a right to an attorney, and one will be appointed to represent you if you cannot afford one. All right, Miss Champion or Mr. Jordan, whoever's managing the host, if you can place me in a breakout with Mr. Walker, Miss Falk, Mr. Howard, Kasha, and Miss Andrea Allaby.
I'm sorry, you're on it. SAP over?
SAP is over, yes.
I heard nothing. I'm sorry. Have a good one.
You too, thank you.
Bye-bye.
Are we going over the calendar?
We done record.
Mr. Royston, stay on mute, please. And you can turn your camera off
Okay.
and I'll text you.
So we're asking that he be released to our investigator
All right, this is Judge Law returning on the competency calendar, courtroom 2. Can you hear me?
I hear you, Your Honor.
With regards to Mr. Donald Stafford, the court's going to issue a release order that he be released on November 15 or 16 with conditions, and his attorney will speak to him about those conditions.
You heard that, Mrs. Sampson? Okay, Your Honor.
All right. Do you have anyone else from the competency calendar in your courtroom?
No, he's in medical, Mr. Baum. He's on
I got position 4 here, Judge. Mr.
All right,
Vice-
and so everybody else in courtroom 2, we've addressed them?
Yep, this
All
is the
right.
misdemeanor that's behind you.
All
Behind
right.
me.
All right, thank you, thank you.
All right.
Okay,
Thank you, Your Honor.
Mr. Baum,
Yes, position 4 here, Judge.
position 4, is this the sign interpreter case?
Yes, ma'am.
All right, Mr. Jordan, do we have the sign interpreter present? Miss Champion, do you see a sign interpreter? If there's a sign interpreter, we had requested it, but
No, ma'am, I don't see one logged on at this time, but I did put in the request for one to be here. Let me check with Miss Cardi the cook to see if she's heard anything from the interpreter.
all right. Officer at the Baum location, we can only address Mr. Baum once the sign interpreter comes back on. So I'm going to go into the breakout to handle my other cases, and I'll be back shortly.
Okay.
All right, thank you. Ms. Champion, could you check on the status, please? I appreciate it. Thank you.
Yes, ma'am.
All right, and Mr. Jordan, could you place the rest of us back in the breakout room, please? All right, I think Mr. Jordan or
Judge,
Mr.
y'all all should still have the join breakout room. If you click the breakout room thing on your computer, it should still allow you to join back.
Yes.
Can you put Ms. St. Flex and Ms. Francis in the breakout room?
Can I put who now?
Ms. St. Flex and ASG Francis.
Okay,
This is the PD.
okay.
Thanks.
Mr. Jordan?
Yes.
Just, I am to stay on standby?
No, you can leave if you want. There won't be any more pleas today.
Oh, okay. All right. Thank you.
Thank you.
Good afternoon, everyone.
All right, Miss St. Flex and Miss Francis, you all need to be in the breakout room. Is our sign interpreter present? No?
No, ma'am.
All right, Mr. Baum, we will address your case on December 8th. Dr. Schwenke is going to be talking with you or communicating with you with regards to your case. His case is reset to December 8th. Thank you. All right, Mr. Royalston, we will be with you shortly. We are discussing your case with your attorneys and we'll be with you shortly.
Yes, ma'am.
DeMarcus Royalston?
Ma'am.
All right. Mr. Royalston, this case was scheduled in order to address the status of the outstanding fee still owed to the monitoring company by you. You were ordered to wear an ankle monitor pursuant to my bond order. And now the monitoring fees now exceed $3,000. This is case 21 CR 005-211Y. This was a show cause hearing as to see whether the bond order should be amended with regards to the ankle monitor. With regards to certain new information that's come to light, the court is been advised that the prosecutor is going to file a motion to revoke your bond, and that a hearing is going to be scheduled next Friday, November 18th at 9 a.m. in person in courtroom G33 at 160 Prior Street. You have been advised of your right to remain silent about the facts of the case. Please exercise your right to remain silent and speak with your attorney, Ms. St. Flex, as to what to anticipate at your next hearing. And Mr. Royalston, where is he? Mr. Royalston? Is he dropped off? Oh, he's right. Okay.
It had broke out.
I see
It
you.
went out.
Okay, and then so we are going to address the status of your ankle monitor and a possible motion to revoke the bond if the state files it today. And that hearing is going to be held next Friday, November 18th at 9 a.m. You have to appear in person in courtroom G33 at 160 Prior Street on or before 9 a.m. Do you have that written down?
Yes, ma'am.
Okay. All right. Anything else from Ms. Francis on that case?
Nothing, Judge. Thank you.
And Ms. St. Flex, you've got that date as well? Mr. Walker can let her know. Okay. Is Mr. McLean present or?
And then I'm sorry, our victim advocate on that matter is present. Can Ms. Price be excused, Your Honor? Thank you for your attendance, Ms. Price. You're excused.
Ms. Price?
Thank you so.
We will have the revocation hearing next Friday, okay?
Thank you, Your Honor. Thank you so much. Good day.
You too. I think Mr. McLean, Mr. Jordan, is Mr. McLean still in the courtroom?
He left, Judge.
Okay. Well, if anybody wants to hear the status of the SAP calendar, or we good?
Thank you, Judge.
I would like to hear the SAP. Just on a few, position 12.
Reset SAP 11/17/22.
Reset November 17th, okay?
Okay.
Well, let me just go down the calendar, then that way everybody will be on the same page, because we do have some notes from
Excuse me,
Yes, Mr. Ralston?
am I free to leave?
Yeah, but remember to come back to court on November 18th. Thank you. Okay. On the DV bench warrant calendar, position 1, bond has been amended to 1250 surety, and she has to report to the jail by noon tomorrow. Position 2, 3, and 4. Mr. Lowe did appear. He has to surrender to the jail by noon tomorrow, and he'll be released on a signature bond. And then position 5, Deja Robinson, I've set aside the bench warrant. Okay, on the status calendar, Royalston, that's reset to November 18th, in person in courtroom G33 at 9 a.m. All right, that brings us to the all-purpose calendar. Position 1 was a plea. Position 2 is reset December 1st. Position 3 was a plea. Position 4 was null pros. Position 5, plea. 6, plea. 7 was a plea. 8 and 9 were pleas. 10, a plea. 11 is reset November 17. 12 reset November 17. 13 is a plea. 14 Antonio Jacobs. I didn't get an announcement on Antonio Jacobs.
The chat said he refused to come to court.
Okay, so we'll reset it to November 17th. Position 15 and 16 were pleas. 17 was arraigned and further notice. 18 was a plea. 19 was null pros. 20, Kentavious Martin. This case has been transferred to the DA's office as a felony charge. 21 was arraigned and further notice. 22 is reset November 17 for SAP. This case has been bounced back from the DA's office, so we need to address that.
What position was that, Your Honor?
22. Richard Patatin Quitter.
Okay, I'll take a note, see what's going on.
Yeah, it was sent to the DA's office, then it got bounced back. He was represented by David Houston PD in Superior Court.
Okay, I'll take a note, Your Honor.
Okay. Position 23 is arraigned and further notice. 24, Ryan Owens is going to be reset 12/8 competency calendar. Position 25, Sadler is reset 12/8 competency calendar. Position 26 and 27 were pleas. 28 was arraigned and further notice. 29 is reset. 29 and 30 are reset December 8th competency calendar.
Judge,
Yes, Mr. John?
can you go over the DD bench warrant position 1? I have 1750 for the total bond. You said 1250?
It may be 17, I may have missed one. Okay, let me just.
So you said 500 on the battery, substantial physical harm. And then you had
500 on the.
And then you had 5 additional.
No, that would be, that would be 1750. I missed one, sorry, 1750. Is 500 on the battery, substantial physical harm, and 250 on the remaining 5 charges. So that's 1750 surety.
Okay.
And I'll be doing that order as well as the one for positions 2, 3, and 4 on Mr. Lowe, who needs to hire an attorney as soon as possible. And position 5, Ms. Helen is supposed to submit the proposed order setting aside the bench warrant.
She sent it to me, Judge. I have it.
Okay, all right. Any other questions? All right, folks, thank you.
Thank you.
All right, we'll be in recess until 2 o'clock. Thank you.
You're gonna do the 2 o'clock calendar from home too, Judge?
Yes, I will. Thank you.
Thank you. See you at 2.
Yes, sir.